May it please the Lordship, my lord.
One second. Yes.
My lord, item 9. On last occasion, actually, I was out of station and the matter was missed, my lord. Lordship was pleased to fix it for today. But
On
there is a
dismissal.
difficult. Pardon, my lord.
You wait for your turn.
My lord, the difficulty is this, my lord, that I don't have any contact with the
You
client.
wait for your turn. You wait for your turn. Yes. Wait for your turn, Mr. Sharma. This court will accommodate you, but this court will have to see the file. Yes.
Sure.
Yes, Mr.
But-
Sharma.
Lordship, item number 25, 26, and 27. I'm appearing for the petitioner.
I'm appearing in item number 25, respondent.
And I'm told that one of the cases, final report has already been passed.
Hmm?
Final report has already been passed.
Okay.
So I'm waiting for the instructions.
Instruction.
Yes.
Ah.
Lordship.
Mr. H.K. Sharma, learned counsel for the petitioner submits that in one of the connected criminal petition, he has received instruction that perhaps in one of the criminal petition, the FR has already been submitted. However, he is waiting for the written instructions
Okay.
and accordingly seeks some time to place the instruction on record. Mr. A.K. Goel, learned counsel appearing for the respondent does not oppose the said prayer. Relist, yes, when do you want after?
After
Bihu?
24th of, after view, 24th of April.
All right,
Or second May, second, fine.
yes,
Okay.
May I please your lordship. Lordship's indulgence, I beg to mention item number 20. Lordship, I have some personal reasons I have to leave the court premises. Can the matter be accommodated next week or maybe after the Bihu
20.
vacations? 20, my lord.
As prayed for by Mr. A. Sharma,
Yes, sir.
learned counsel for the petitioner which is not opposed by the other side, relist after Bhikkhu date on such and such date.
Highly obliged.
21st April.
Make pieces of lordship. Lordship, with the consent of other side, I beg to mention item number 10, my lords. I'm playing this, I'm making a prayer.
Have you, I think you had circulated at John.
Yes, yes, my lord.
Your name?
My lord, M. A. Chaudhary.
Mr. M. A. Chaudhary, learned counsel appearing for the appellant by circulating advance adjournment slip with consent from the other side seeks accommodation for
2 weeks, my lord.
2 weeks.
Malad.
Prayer is but it's a 2012.
Yes, yes, my lord.
Released on such and such date.
On 7th May.
7th May.
May please your lordship. Lordship,
Yes.
with the concern of the other side, I beg to mention item number 28, lordship.
28.
28, lordship. Kindly adjourn the matter for the day, lordship. Mr. Pathak is out of station.
Your name?
B. Hazarika.
Mr. B. Hajorika, learned counsel for the petitioner with consent from the other side seeks accommodation in the matter on the ground that the conducting counsel, Mr. B. Pathak, is out of station. Prayer is allowed. Relist.
11th.
Lordship, can it be on 2nd week of May, lordship?
All right. Relist in the month of May on a date to be fixed by the registry.
Obliged, lordship.
Yes, please, your lordship. Lordship, I beg to mention item number 11, your lordship. Lordship, I pray that the matter may be adjourned for the day, your lordship, due to certain personal
It's a
difficulties.
2012 appeal. Why?
Yes, your lordship. Lordship, certain difficulties are there, your lordship.
As prayed for by Mr.
KJ Saikya, your lordship.
K.
KJ Saikya.
K.
K.
KJ Saikya, learned counsel for the appellant, which is not opposed by the other side, relist next week, but our next week date silo, जो basic matters next.
9th.
Deeply obliged.
Please call the list.
For admission, item number 1.
My lord, this is a revision petition, my lord. Here in this case, my lord, the conviction passed by the learned SDGM was upheld in the appellate court also. The conviction was that fine of rupees 150 rupees. My lord, the conviction,
Offense is 379-427-447.
but no, punishment was given under 447 and 427. Others were not established.
Yes, where is the order?
kindly see the learned trial court's order at page 12.
Yes,
Actually, basically, this is a case of boundary dispute. Prosecution believes that on a
what dispute?
boundary dispute.
Boundary dispute.
Yes. And that all the accused person entered into the house of the complainant by criminal trespass and destroyed boundary fencing and cutting down the betel trees and stolen away. While complainant protested, same not to do such illegal act, accused used slang language towards the complainant. The accused person caused losses of rupees 40,000.
You are
Yeah.
reading from where?
Page 12.
Yes. Yes, please.
After recording the initial deposition of the complainant and statement of witnesses, cognizance was taken against the accused named in the complaint petition under section 147, 447, 379, 427 IPC and process the issues thereof. Accused thereafter entered their appearance in court in two witnesses on behalf of the complainant examined before charge by the order dated so and so. Framed recorded of the accused to which all the accused pleaded not guilty and claimed to be tried.
All right, page 14, PW1.
PW1. The complainant deposed that on the incident day, all the accused person entered into the residence of the
Mr.
complainant.
Ghosh, just 1 second. Yes,
PW1 complainant deposed that on the incident, all the accused person entered into the residence of the complainant and cutting down the betel trees and remove it while the complainant protested the same. Then accused person threatened the complainant with dire consequences. PWT also supported the evidence of the complainant PW1 and corroborated the same. On the day of incident, all the accused person criminally trespassed into the residence of the complainant and broken the boundary fencing and cutting down the betel nut trees. But from the evidence, my lord, I have gone through the evidence. Not a single sentence has been whispered about all the accused persons named. In cross-examination, only two names has been given, Abdul Hanaf and Minu Ahmed.
Abdul Hanat is
Abdul Hanif,
petitioner number
8,
P8
and this Minu Ahmed,
P.
7.
What
And
is, do
apart from that,
do
my
you
lord,
have the cross-examination?
and no eyewitnesses.
Do you have the cross-examination?
I have.
Please read.
It is in vernacular. my lord. May I read?
Read it, please.
Operative part I am reading my lord,
Yes.
only. আমার বাহিরা লগ্ন দলিলে আব্দুল নূর আব্দুল হালিম গয়র লোয়ার বাড়ি পূর্বে দিস ইজ দি ডেসক্রিপশন অফ দি বাউন্ডারি গিভেন আব্দুল শুক্কুর আমার চাচাতো ভাই PW1 did not name anything. PW2 given rather name. PW2 I am cross examination part I am reading. ঘটনাস্থলে গিয়া বাদী চাচা 15, 25, 30 জন লোক পাই তাহাদের মধ্যে রিপন চৌধুরী আব্দুল হালিম ছিলেন তাহাদের মধ্যে he found 20 to 30 persons assembled there out of which তাহাদের মধ্যে রিপন চৌধুরী
Means amongst them.
among them রিপন চৌধুরী and Abdul Hamid কে পাই two
That-
names has been given
That's all right.
he has given only two names.
When you said, I thought only specific act has been attributed to only two persons. That's why.
No, name.
That's okay.
My submission is that they even did not name
No,
any of
but
the person.
they are saying the other persons accused.
But on the basis of whether on the basis that too,
They have said that all the accused and persons entered into the residence, not necessary to name them. They are.
all neighbors.
You see, Mr.
all are
Ghosh,
neighbors.
the problem is that you are before a revisional court.
Yes,
This court is not going to now appreciate and reappreciate the evidences of
No,
the trial court and the appellate court. You will have to point out the error which is apparent on the record of the judgment of the appellate court.
yes,
right?
my lord.
You are
Correct.
for a limited jurisdiction.
Now kindly see the judgment, my lord.
Yes,
Now kindly see the judgment.
if you
After-
point out the error, I will allow it.
Page
But that
30.
is what you have to show, Mr. Ghosh.
Kindly page 13.
Yes.
Now point for determination. Whether all the accused person on 6/12/2009 at about 7 AM were the number of unlawful assembly and prosecution to common object of the said assembly committed an offense of rioting and thereby punishable under section 147 IPC. Whether all the accused person committed criminal trespass by entering upon the homestead of Aklas Ali in the possession of him with intent to commit an offense punishable under section 447 IPC. Whether all the accused person committed mischief by causing wrongful loss or damage to the property of Aklas Ali, value of so and so thousand, thereby committed an offense under section so and so. Whether all the accused person intending to take dishonestly cut down trees of Aklas Ali without his consent and move it in
These
order.
are points for determination.
No, no,
Mr.
if-
Ghosh, you point out from, because you see PW1, PW2 evidences are there. It's not a case that the evidence are. You please read after the cross-examination. Let's,
now after the
Page
cross-examination,
14.
point for determination is very important.
you read.
Yes, page 14.
Yes.
PW complainant deposed that incident day, all the accused person entered into the residence of the complainant and cutting down the betel nut tree and remove it. While the complainant protested the same, then accused person threatened the complainant with dire consequences. PWT also supported the evidence of complainant PW1 and corroborated the same. On the day of incident, all the accused person criminally trespassed into the residence of the complainant and broken the boundary fencing and cutting down the betel nut trees. In cross-examination PW1 and PW, there is no corroboration made out by the defense side. A charge under section 147, there is no evidence at all. Though the PW1 adduce evidence, but not tally with PW1. So under section 147, there is no material for punishment of the accused. Regarding section 379 IPC, the evidence adduced by the prosecution witnesses not at all sufficient to punish and not convict accused person in this section. Learned advocate for the defense at the time of the argument raised objection that complainant filed this was after 4 days of the incident and occurrence took place as alleged in the complaint petition. As Khalil Uddin is the eyewitnesses of the incident, but he was not examined by the prosecution side. In the cross-examination of PW2 admitted that at the spot he found 20 to 30%, but prosecution side did not examine any of them. PW2 is interested witnesses, is the nephew. None of the independent witnesses examined by the prosecution side. As already discussed above, there is no allegation proof under section 147 and 379 IPC by the prosecution side. On perusal of evidence on record, prosecution side able to prove that all the accused person forcefully trespassed into the land of the complainant and cutting down the tree and caused loss or damage to the complainant. Hence, I found that all the accused persons are convicted under section 447.
Appellate court judgment.
So this judgment is contradicting
Appellate court judgment.
himself. Appellate court judgment page it's
23.
23.
Yes. You may read from
Read
para
from-
5.
Yes, para 5. Peruse the evidence adduced by the complainant side minutely. Complainant in his examination in chief has stated that on the day of incident at about 7 AM, accused person had entered into his land and committed mischief, thereby cutting about so and so number of trees. He further stated in his evidence that when raised alarm, neighboring people came there and resisted them, but accused person did not heed to the protest. Due to the aforesaid incident, complainant had sustained loss around rupees 40 to 45,000. The learned counsel on behalf of the appellant had cross-examined the witnesses at length. Although learned counsel on behalf of the appellant had cross-examined the witnesses at length, but he did not able to break the case of the complainant. PW2, Abdul Shukur also corroborated the statement of the complainant that on the day of incident, appellant armed with dao, lathi, and other weapon had entered into the land of the complainant and committed mischief, thereby cutting about 20 to 25 numbers of betel nut trees and other valuable trees, namely mango trees, bamboo trees. The said witness did not mention in his evidence above amount of loss sustained by the complainant due to the aforesaid cutting of trees. Learned counsel on behalf of the appellant had cross-examined the witnesses at length, but he could not able to break the prosecution case. The said witnesses had specifically stated in his evidence that the accused had criminally trespassed into the land of the complainant and had committed mischief, thereby cutting valuable trees, namely so and so, so and so.
So
So,
basically relied on the evidence of PW 1 and 2 to the effect that you had, that the accused had
Entered into-
had entered into the premises and
Premises
had
and
broken the wall and cut trees.
not wall, cutting the trees and all
Cutting
these
the-
things.
All right, we are admitting it. Heard Mr. S.K. Ghosh, S.P. Chaudhary,
SK goes.
S.K. Ghosh. S.K. Ghosh, learned counsel for the petitioner. Also heard Mr. M.H. Rajbor Bhuya,
Yes.
learned counsel for the respondent.
Yes.
And S.H. Bora, learned APP for the state respondent. The petition, not appellant, the petitioner. The petitioner has made out a prima facie arguable case. Admit no formal notice as parties are represented. List, it appears that the TCR has already been received. List for hearing when
After view vacation
on such and such date did your,
or in the month of May,
all right, in the month of May on a date to be fixed by the registry.
month of May.
All right. Item number 2.
Affidavit was supposed to be filed by the petitioner also on the last occasion.
Additional affidavit is also not there. Petitioner is also not there. Hello, piece of management.
Item 3 and 4.
Mr. Bora? I think it's your matter.
Sorry, madam.
No problem. Yes, what is this petition? It is a petition and connected revision petition.
No, madam, that's a, yes, madam, against the framing of charge, madam.
Against framing of charge is the petition. Or petition is against the FIR,
No, it's a framing of charge, madam.
the petition,
Yes,
that is 1256.
1256.
Petition is against the charge framing.
Charge framing, my lord.
And
The-
charges were framed under section 4, section
Madam,
306
306. By 34, abatement to commit suicide, madam.
And which is the revision that is against the order of,
Same order,
Huh?
same order, they have.
why,
filed
some other party has
it.
filed.
Other party.
There are two accused.
Two accused, madam, they have.
One
filed it.
has filed a revision and one has filed a
Petition.
okay.
Basically, my lord, it's on prima facie, my lord, there is no instigation on the part of the petitioner, my lord. For committing, my lord,
Abetting.
abetting, my lord. The there's a one dying declaration, my lord, sorry, my lord, suicide note, page 20.
If you don't mind, can we first go into the FIR and then you can
Yes.
take me to wherever you would
FI
want,
lordship will find page 10.
page 10. Yes, please.
Most respectfully, I beg to state that on 18/12/12, my father, Praveen Soikia, committed suicide by hanging himself in our rented house located at New Guwahati. In this regard, we had filed an Ejahar at the Nunmati police station, and the case being numbered at UB case number 42 of 12, registered by the Nunmati PSN. During the preliminary investigation, 2 suicide notes were recovered from the pocket of the dead body, and upon going through the said suicide note, it was found that one Sri Lakhinan Pegu and one land Rina Thakuria, assistant engineer of the irrigation department, Chanmari, had instigated my father to commit suicide. So the FIR is based on that suicide note, my lord. The suicide note, Lordship will find at page 20 now.
Yes.
The only reason for my death is the assistant engineer Lakhinandan Pegu and the Lina Thakuria technical wing of the irrigation department, who took 3,000 in cash 1 year back for a job, and till now there's not neither the job nor the case. I had told Pegu that I have no money and I can give money only after resigning from job. He has assured me a job. For that reason, I have resigned from the job. All the office staff of my office know about that. I have no means to run my livelihood, and there is always a quarrel with my landlady.
What is
Because-
this? I had told Pegu that I have no money and can give money only after resigning from the job.
So he was doing some job in somewhere, so he has taken the voluntary retirement.
No,
And
but
the-
initial part, he says that so and so has taken rupees 3
3 lakhs in
lakh
cash
in cash for a
1 year
job.
back.
Until now, there is neither the job nor the
Yes,
cash.
1 year back. that
1
is.
year back.
So-
And then he said that he has no money.
He has no money.
And why again, and can give money only after resigning from the job? This is, he's saying about whom? Himself.
Yes, himself. So I have no money, so he has said that I have to resign from the job, then I can pay you. So accordingly, he has resigned from the job as we have assured. For that reason, I have resigned from the job. All the office staff of my office know about that. Now I have no means to run my livelihood, and there is always a quarrel with my landlady because if the electricity bill comes to 1,100, we have to pay 9,000.
So he
I have-
resigned from the job
Yes,
to give this rupees 3 lakh.
3 lakhs.
This is what he's saying.
Yes. So what?
It is unbelievable on the face of it.
Yes. And that too, my lord, the committing suicide, that too payment was made. Let us assume it was made payment.
No, nobody is appearing for the private respondents.
Sorry.
Are there any private respondent complainant? Yes, number 2. Notice have been served.
He
Huh?
he was living in a rented place.
He was?
He was living in a rented place. So we will try our best.
No,
to
but
start-
is notice is presumed as
Yes, sir.
there is an order? Yes.
There is an order.
No, the 31/5/2022, it says, in view of the report of the process server, the petitioner shall take fresh steps through officer in charge of Nunmati police station. Thereafter, nothing is recorded in any of the judicial orders. Now, after 31/5, what does the office note say? 25/9 says no fresh step for service of notice upon the respondent number 2 has been received by the section.
Yeah.
After that, the office notes does not say anything.
310, my lord, 310.
310,
310/24. Justice P.J. Shakya, my lord.
I think it is in the other case. Sure, next to Choksan, 310 or it would, office note 9. It's come up for admission today, right?
Balance.
Oh, 5/6/20. 5/6/20, notice was issued. Affidavit regarding dusty service of notice has been filed by the petitioner. notice issued by registered post has been received back unserved with postal remark addressee left. What is to be done? Because it seems that he has left as of date. The notice has not been,
But nobody knows also about my, that's the difficult.
you have a stay order?
Yes, I have a stay order cooperative.
I can admit it and maybe issue fresh notice. You try, otherwise because
Or Lordship can
on the
appoint.
face of it, doesn't appear that a case of 306 is made out. Merely because some transaction happens, one will commit suicide and blame it because how can that be?
That too 1 year back, man. There has to be proximate connection.
No, it doesn't inspire the, but anyway, since notice is not, service is not presumed and it appears that not served, it will not be right for me to dispose it at this stage. So you already have an interim order.
You can admit it and Lordship may appoint an amicus that case.
So, but why don't you try once?
Try also.
He's untraceable. He was in a rented place, he left, we searched.
No, but what job was he doing?
He was in.
Sorry?
India government. This is was working in an India government below. His son below, we are not aware. He was retired.
Make a paper publication. In his, wherever he was last staying, make a paper publication. At least there will be something for this court to proceed with, because right now, this 5-6 notes shows that notice is returned back, addressee left.
We'll make
I
a
think
paper
we can make
publication,
a
madam.
publication.
Lordship kindly reflect it, we'll make it, madam. That's all.
Heard Mr. A.M. Bora, Learned Senior Counsel, assisted by Mr. Dhar.
Yes.
A. Dhar, Learned Counsel for the petitioner. In both cases, you are assisting, or in one cases, Mr. Day, you are also there?
I'm in the other case.
And in the second case, to Likhiba, A.M. Bora, assisted by Mr. R. Day, huh? And also heard MS S.H. Bora, Learned APP for the state respondent. It appears that the petitioner has made out a arguable, prima facie arguable case, admit no formal notice as per against respondent number 1, as respondent number 1 is represented by MS so-and-so, Learned APP for the state. It appears that though notice was issued upon respondent number 2 by Dusty as well as registered post. However, office note dated 5/6/2020 in criminal revision petition number 494 of 2019 indicates that the notice issued by the registered post was received back with the received back unserved with the endorsement within quotes addressee left. It further appears from the affidavit, so from the service of affidavit filed by the petitioner. Where is the affidavit? Aveta file is nahi correspondent. No, no. It was flag A.
22/11/2009.
One sec. Flag A, that's 191. You have a copy, please, just Burwa, I need access. Paisa. Oh, after. It appears that when the petitioner went to the house of the, went to the address of the respondent number 2, it was learned that the respondent number 2 and his family, who were tenant, had sold, no, who had left Korea, had left the rented premises, and his whereabouts is not known by the local residents of that locality. Correct?
Correct.
In view of the aforesaid, in view of the above, petitioner is at, petitioner is, no, in view of the, in view, Mr. A.M. Bora, the senior counsel, submits that since the address of the respondent number 2 after shifting is not known, can the jurisdictional police officer, can he find out? Should we ask for a report as well as a paper publication both?
Go for it. Well, again, that police officer has to go to the previous address.
If we find out, he'll give a report also. Give me it in October. In view of the above, let the petitioner carry out a paper publication in two newspapers, one in English and one in local daily, having wide circulation in the state. It's Guwahati, right? Last in the state of in Guwahati city. Stop. That apart, let MS.SH Bora, learned APP for the state, call for a report from the jurisdictional police station as regards the address stroke status of the respondent number 2. Let call for a report because
Yes.
ultimately it is the complaint has been filed, complaint or FIR? FIR has been filed.
The copy of the order may be.
Let a copy of this order be furnished to all the councils by the registry.
Obliged.
Interim, if any, shall continue to the next date of listing. Or list after 3 weeks. Good.
Yeah, it is good.
3 weeks, Mr. Dev? 3 weeks. On a date to be
It's-
published.
it's good to give up.
Bail hearing, item number 5.
Yes, Mr. Manan, this is that case.
Yes, Lordship.
This is a case, your lordship.
What about the
TCR not received as per office law, Lordship.
Here,
when can you give it?
Lordship, TCR, Lordship.
Or TCR?
Yes, Lordship. They're supposed to be there,
It should
On
have
record.
come, it is FTC.
but
come-
as per office note 2403, perhaps it is not there.
When can we have it?
Lordship, we hope it's not on.
It appears that the TCR has not been, TCR called by this court by order dated 5/3/2025 is still awaiting. Let registry forthwith send reminder for the same. Relist, yes, please tell me when.
lordship can take it up somewhere in the, on 8th or something, of April.
8th of April,
7th or 8th.
all right, 7 by 8 April, did you look up?
What?
Yes, I thought.
7th, 7th.
For orders, item number 6.
Yes, Mr. Barali.
Here is the office note regarding service of notice to respondent number 1. Already we have taken steps 3 times. but
Not received back.
Not received back. So that was taken in the year 2018. We have taken three
You have
times.
taken 3 times.
3 times and he is the complainant. The proceeding has been stayed. So simply avoiding. He is aware of this proceeding.
Proceedings are stayed.
Proceeding has been stayed long time back, that
But,
is in 2016.
We'll post it after 3 weeks
After
let's see.
vacation. After vacation.
if something happens till then.
It deemed to be served.
It appears thrice and this last order is of 15/9, sorry, 21 March or no. Notice was issued on 13/9, 13/9/18 or 13/9/8?
18.
18.
3880. And LCR has also been received. And it's a complaint proceeding,
Is it admitted, not admitted?
not admitted, so it must come up for admission.
LCR has been, TCR has been received, let the matter be fixed for hearing
And
in the admission column also. In the
it
meantime,
is
notice-
leading to
No, but
500.
in the
that is,
meantime, a fresh notice has to be
No
taken
place
by the.
notice. He
Because
simply
it's a
avoiding my
complaint
notice.
case, Lordship.
all right, I'll admit it and I'll, because at that time, admission stage is also, we try once more. After
Yes,
that,
yes,
we'll
yes.
see what happens.
It's a
Let it come up for
complaint
admission.
I can admit it now.
It
yes,
will
yes.
be for hearing only,
case. Just a matter for admission hearing.
admission hearing. Come up
Since
for
the
admission
TCR has
hearing.
been received.
All right, it appears that the TCR has been received, fixed for admission next week on a date to be fixed by the registry.
In the month of April.
April,
April,
okay.
after vacation.
After vacation date on such and such.
Oblige, my lord. On 25th April.
Item number 7.
Yes, Mr. Biswas,
May I please,
service on respondent, private respondent,
is yet to appear, my lord, because no, the service has not complete, my lord, it appears,
not complete.
not complete. So I have to take fresh steps. Procedure, my lord, Karimganj.
Office note dated 21/3/2025 indicates that notice, that unserved notice in respect of respondent number 2 has been received back with postal remarks within quotes not known. Stop. Mr. S.E. Biswas, learned counsel, appearing for the petitioner, seeks 2 weeks' time. Six accommodation to take fresh steps upon respondent number 2 through the
Procedure.
learned court of Chief Judicial Magistrate
Karimganj.
Karimganj. Prayer is allowed, relist after 3 weeks on a date to be fixed by the registry.
Item 8.
Yeah.
Lordship, as per order dated 14/5/20, we were directed to take fresh steps and accordingly, so we have taken, but service is not complete. Correspondent number 2.
Await service. Relist after 2 weeks
Lordship,
on a date to be fixed by the registry. What is your name?
N.R. Sharma on behalf of A.K. Bhuyan.
Item number 9.
With sincere apology, my lord, on last occasion, my lord, I was out of station and the matter was missed, my lord. I beg your lordship's pardon for this. And today what happened, my lord, to be fair to the court, my lord, this file is misplacement. I don't have a contact with the client also. If lordship fixed in the first week of April, any fixed date, my lord?
This matter was listed today in the order column with the remark for dismissal as on the last occasion. I-23/2025, there was no representation on behalf of the petitioner on call. Today, when the matter is called, Mr. A. Hamwa, learned counsel, has entered, learned counsel for the petitioner is present. Also heard MS K. Fukan, learned counsel appearing for
Solely
respondent. In view of the appearance of learned counsel for the petitioner, relist on
Any date in first week.
date on such and such date this is supposed to be in the admission column,
Yes,
After
admission.
vacation,
in the.
can it be after
For
vacation?
admission.
Can it be after vacation, your lordship?
For vacation, for admission.
Obvious.
20.
Sorry, Lordship, regarding item 8, we had an interim order made continuing.
In item 8, quota, interim if any shall continue to the next date of listing.
Supplementary list item number 29.
For this reason, lordship.
None appears for the petitioner on call. Heard MS Ashish Bora, learned APP for the state respondent. It appears that on the last occasion, I-2403-2025, also there was no representation and hence the matter was listed today in the order column with the remark for dismissal reflected in the cause list. Despite the same, there is no representation today as well on call. Accordingly, the revision petition stands dismissed for non-prosecution.
Item 30.
By interim order as in case of. Ms. Bora, just see if there is any interim order.
Yes.
Did you get a side of it?
30.
Yes, 30.
This is a complaint law. I beg apology.
Yeah,
Regarding
I beg-
item number 7, there is an interim order, but that is.
7 interim order, if any, shall continue the next day. All right, Mr. Vishwas. Yes, item 30.
Petitioner is absent, madam.
Yes. None appears for the petitioner on call. Heard Mr.
Yes.
Your name?
D. Bora.
Mr. D. Buragohai.
Bora.
D. Bora, Learned Counsel appearing for the respondent, and Mr. P.
PS law.
PS Locker, Learned APP for the state respondent. Stop. It appears that this matter is listed today in the order column with the remark for
Yes.
dismissal reflected in the cause list, as on the last occasion, there was no representation on behalf of the petition. It further appears that it appears that that earlier also, earlier in October, it appears that today, it appears that there is no representation on behalf of the petitioner consecutively, despite the names of the five councils being reflected in the cause list. That being so, the petition stands dismissed for non-prosecution. Interim orders, if any, stands vacated.
For hearing, item number 12 and 13.
Yes.
This is a reason directed against the order of conviction, my lord. Passed by the learned judicial magistrate, my lord.
Under NDPS Act.
No, it is under the 417.
This is 12 and 13. 12 and 13, Mr. Kotoki?
Yes.
417A.
Was of the Guwahati Municipal Corporation in 1971.
Yes.
The initial judgment was passed by learned chief judicial magistrate, my lord, in CR case number 7769 of 2007. my lord. It was judgment and order dated 14/6/2010.
Page.
There. Then that was confirmed by the learned section judge, my lord.
Yes. Appellate court.
Yes, appellate court by judgment and order dated 1/12/2012.
All right.
Now I'm coming to the first complaint, my lord.
Yes.
That complaint you will also find at page 14. my
Let's
lord.
go to the trial court first, because since you are in a criminal petition, you are in a revisional petition.
Yeah, I understand, my lord.
Yes. So let's see, where you
Your lo-
show me from the judgment, what is the error? If
And
required,
then basically, I'm just, you'll notice, for the facts of the case, I'm just placing the complaint, my lord.
all right, page,
Page 14 is the complaint, my lord.
okay. Yes, please.
A complaint petition, there is a complaint petition filed by Guwahati Municipal Corporation for violation of building bylaws of GMC Act 1971, my lord. And it was filed by Guwahati Municipal by Deepak Besborua, Associate Planner, ma'am, to by the corporation, my lord. According to them, my lord, this accused number 2, my lord, your lordship may kindly come to page 15, my lord. Paragraph 2, it starts, my lord. Paragraph says that complainant is a duly constituted statutory body which having separate identity, we use whose principal office and administrative affairs, and same is the president in above referred person which duly authorized to lead this person prosecution on behalf of GMC. So he has claimed that he has been authorized by GMC to represent, but there was no authority letter, my lord. That we have come in cross examination. Then paragraph 2, my lord. Accused referred above is the managing
Mr.
director.
Potoki, you understand that you are before a very limited jurisdiction. Now, these are all factual aspects. Before we go into all that, first
But
you have
that
to
has been
show
raised,
me.
my lord, that has not been answered, my lord.
No, you have to show me what is the error which is manifest on the record from the judgment.
I'm coming to my, just.
Now, let us first go to the appellate court judgment. If you convince me something is there, then obviously this court will look into the evidence and all. But first, let us go there. This court cannot directly go to the facts
No, facts,
in
but
a
just.
revisional, where you're seeking the court to exercise revisional jurisdiction, isn't it?
Yeah, understand, my lord, but fact, yeah.
Yes, let's go to the appellate court judgment or the trial court judgment as you wish.
Appellate court judgment, you'll also find, the trial court judgment, you'll also find at page 59, my lord.
Yes, I have 59.
There, my lord, you'll also, judgment is, it starts from page 60, my lord.
Yes.
There says constituted under Guwahati Municipal Corporation. The Guwahati Municipal Corporation is a statutory body granted permission to Starline Appliances for construction of RCC Hotel plus 1.54 at Mohammed Shah Road. The general engineer visited the said premises and after holding that inspection verification detected erection of 7 and 8 floor of the building and several comprising of several rooms in violation of GMC Act. And notice under section 37(1) and 2 dated 15/5/92 was issued to them accordingly. Pursuant to the notice made a reply dated 19/5/2000 and 225/3/23/2000, which is found not acceptable. There a final notice was issued on 337(3) on 5/8/93, and necessary action has been initiated to demolish the immediate part. Accused before the writ petition, so it's WBC number 1261, and which was dismissed on 19/9/2007. Thereafter, 25 the zonal officer inspected premises and under the supervision of magistrate and engineer prepared a report. Then that on 25/9/2000, the accused filed another writ petition so and so, which was dismissed with cause. Thereafter, following the order under various norms, unauthorized has been demolished and accused has contravened the bylaws by erecting building unauthorized, and they are liable to be punished under section 47A Roman 2 of GMC Act as amended. GMC through his authorized representative has lodged a complaint against Starline and its managing director Suresh Gayodia for their prosecution under section 47(1)(4)(7)(a) 2 of the GMC Act. And taking cognizance of the offence, the accused is summoned to appear before the court, and the accused person appeared so and so and explained and they pleaded not guilty. Points for reason: whether the on 25/9/2000 constructed building beyond the limit so and so controversial. To establish the culpability of accused, complaint examined 2 witnesses, namely Saved Ali as PW1, one on Deepak Besborua as PW2, authorized representative of the complainant, and exhibit some inspection report, exhibit 1, status report, NOC. Defense had examined Uttam Kumar Sharma, DW1, exhibited money received, exhibit A. We've gone through this carefully. The evidence of PW2, the common reveals that on 10th of March, one so and so was granted to the Hotel Starline, accused Starline for construction of commercial building, ground plus 6 floor. Thereafter, as per the direction High Court, 9 officers, including the magistrate, inspected the site and found construction of 894. His evidence reveals that they were detected ground floor deviation, so and so the deviation part that that they have unauthorized construction work. They have also found margin deviation in not so and so, so and so. And exhibit inspection of exhibit 1, thereafter having demolished the unauthorized, they prepared a status report and submitted to the so and so. PW2 stands corroborated from the evidence of PW1, Saved Ali, that he is a zonal engineer of GMC. He accompanied so and so inspection. His evidence reveals that he inspected the hotel and found deviation in the ground floor, so and so, in the 8th floor as well in the 9th floor. And NOC was issued so and so. They also found margin of 0.51 meters on the north side setback margin, so and so. That part you will also can, that part they have, what about the margins they have calculated by it. And the accused is maintaining approved operation of so and so as per so and so. Then page 63, paragraph 8. Defense side process PW1 at length. It could not elicit anything intangible to increase their version. What is examined in chief content undisputed out of cause. Though PW category, he has been authorized to lodge a complaint against Suez as the owner of the Suez. What is transferred from evidence of PW1 and PW2 that on 25/9 they have allowed inspected the premises as of 7, 8, floor, 9 floor and deviation in aspect which are provides for erection and it provides that no person shall erect any building, that they have quoted the provisions of law regarding erection. Then section 328 that has been quoted, your 327, 328, and then comes 416 that these are the provisions of the section of GMC. Then page 66. Having constructed 7, 8 floor without the permission, having deviated the construction of 401 to 6 ground floor margin number so and so, so and so, so and so, so and so, coverage of so and so, the same are not compoundable limits as contravention above the provisions under section 47A. If a builder or promoter or owner erects or occupies any building in contravention or provision to act rules, bylaws made therein, except the provisions of compoundable limit as provided by the bylaws, he shall be punished with imprisonment of a term for 6 months along with fine. The defense side could not outweigh the evidence and prosecution. Whether the defense witness vindicates the version of the prosecution. The defense of defense reveals that during his tenure as general manager from March 2000, he constructed obtaining permission of 6 floor. The municipality inspected the building, detected deviation from original plan, then the skyline and preferred an application to the Minister of Municipal Administration. Minister authorized one letter to 19/12/91 to the GMC with the endorsement of the commissioner proceed to take necessary action for rectification and regulation with penalty, if any affected are GMC. Thereafter, 26/92, Starling Licenses deposit of fine of rupees 7,900 by receipt 20. Land Council prosecutor has submitted that during the argument, evidence of D1 exhibit have no bearing in the case, as NOC exhibit 6, based on which the case has been issued on 10th of March 92, and any violation regulation would not affect the merit of the case. As a defense counsel submitted, since the offence is detected long back and notice under section 337 1 and 2 has been issued on the basis of the same, is required fine has been paid for contravention. The provisions of Amendment Act came in 17 of August 2006 is not applicable here. In this case, as no retrospective habeas or penal status has been given in this case, Learned Defense can therefore contend to record of acquittal. So basically, our contention is that whatever violation took place, it was prior to amendment. That is our case. We consider points raised by Learned Defense can we analyze the facts and circumstances of the record in light of the same. Defense also perfectly in submitting that no retrospective or penal statute can be given. Article 21 of the Constitution immunize a person from penalty greater what he might have incurred at the time of committing offence. But the
Your argument is that this contravention, even if assuming to be correct, then it is prior to the amendment.
And prior to the amendment. Yeah, but the fraudulent concept cannot be ignored in case the offence has been detected by the PW1 to an official on 25/9 March prior to coming of the amendment. It is what mentioning in this context amendment.
Slowly, Mr. Kotoki.
Yes. In this, that page 68, your lordship, paragraph, internal page 10, top portion. Poison circumstances cannot be ignored in this case. The offence has been detected by PW1 and 2 and other officials on 25/9/2007 later, after coming force of the amendment. It is worth mentioning that in this context, Amendment Act GMC came into force on 17 August 2006. It is of course true that as per submitted by Learned Defense Counsel as stated in the complaint petition, the 337(1) GMC Act was issued, notice was issued on to the accused on 15/8/93, and but the said notice was nothing to do case in hand. Notice was issued under said section relates to pulling down removal of the work not in conformity with the bylaws. For the
Where,
sake of-
where in the evidence, it is stated at what time these constructions were completed, the 7, 8, 9?
That evidence your lordship may kindly come, that I have enclosed, my lord. That your lordship will kindly come to evidence part, my lord, that I have enclosed.
Is it reflected in the judgment?
Not reflected, but PW1 evidence is there. That is page 35.
There must be, because completion certificate and all that, have you brought that on record?
That was not brought, but there was deviation, my lord.
No, I'm not talking about the deviation. Because, you see,
92, it was completion certificate was there, man.
that's what I'm asking, because when did the amendment come?
2006, man.
2006, and the inspection was done in 2007
man.
when when this was detected.
Detected.
But that is, they have detected in 2007. But if this construction was done
Because
earlier, and it is proved that it was done prior to 2007, then perhaps the this section, this amendment could not have been applied. Mr. Bora, are you getting what I am saying?
Yes, sir.
Because you may have detected this, but if suppose at the time when he had constructed the 7, 8, 9th floor, at that time there was no amendment, and that time this construction was valid, then how in 2007 only when you detected you could say the courts can hold him guilty? This is something going on in my mind. So you can address me at your turn also. But Mr. Kotoki, that's why I'm asking, where is the admitted documents? Because you must, as a builder, you are a builder or you are a...
Here in this case, a company has been made a party. And one more important thing, my lord, is Suresh Garodia, my lord. He was implicated as a managing director. But
No, all that is okay, but you see, admittedly, there should be some document showing when this bill, because completion certificate is given after entire thing is completed. Correct, Mr. Bora?
Yes, my lord.
Now, has those documents been exhibited or not?
The only inspection report is exhibited.
Inspection
report is exhibited.
Inspection report, does the inspection report refers to the date of completion?
No, man, doesn't say.
The inspection report, Lordship will find in page number
Now, suppose this is not there, then how, but where have, in your evidence, where have you said? Page 35, you were saying.
Yes,
35 is the inspection report.
But what has happened, my lord, on 26, for the deviation, we paid a fine of rupees 7,900.
When?
On 26 to 92, man. That is page 40, man.
This is regarding deviation, floors. Floor cannot be compounded, my lord. Addition of floor cannot
That
be.
was in 92, man. Page 40, man.
Yes.
Yes, page 40.
Yes, ma'am. 40. Then I have been working, so the permission was granted up to 6th floor. Municipally found deviation were originally open upon inspection.
1 second, I have been working so and so from 2000. Has constructed hotel building. Permission was granted up to 6th floor. Deviation, made an appeal before the to regulate on that. Issued a letter in 1991. And sitting there in the... Where is this letter? Is it exhibited?
It is exhibit call, my lord.
Call is the receipt.
Receipt, man.
What about the letter?
Letter is not exhibit. Call. And that part also admitted by them also, by the prosecution.
Is it an admitted fact?
Lordship queried that whether that particular building, the 7th and 8th floor, 9th floor, has
Correct.
come
After
before
or-
the before.
Correct.
Lordship turn to page number 30.
Page number
30.
30.
30. This is the notice under section 337, 1 and 2, dated 15/5/92.
13 is illegible in my copy.
Well, there is a type copy also.
Yes.
Yes, Lordship will see, this is dated notice dated 15/5/1992.
Yes, please.
Down below the schedule 1.
Yes.
nature of
Construction
construction.
of 7 and 8.
Yes, it has come in 92 only. 92 it was there,
7 and 8.
7 and 8. So this is a G+6 building, 7, 8, 9. These are non-compoundable offenses.
Now,
Addition of floor-
now your case is 7, 8 and 9.
7, 8 and 9.
Now, what about 9? When did they construct 9?
No, 7, 8 is
already 7 and 8 then in 2019, 92
So you see,
itself notice.
so in that case, as regards 7 and 8, perhaps the amendment will not be attracted. Amendment is of 2005. And they have built this in in the year 1992,
No, no.
because or
19
prior to 1992.
9 to 92, they have constructed 7 and 8 now. And
Now,
already
at
there-
that time, whether this was a penal, whether there are any penal consequences?
the penal consequences came on 17/8/2006.
Correct. That is why I am asking, Mr. Bose, you're getting what I am saying.
Yes, 2006.
So as far as 7 and 8, admittedly, it was prior to 1992.
92.
That is prior to the amendment, isn't it?
Yes, yes.
In that situation, how can, perhaps
Madam,
for
I-
these 2 floors, they cannot be penalized. No offense can be said to be made under an amendment, because that amendment was not even in existence
That was not
at
in
that
it.
time. Now, what about the 9th floor?
9th floor, I don't find any document. my lord.
Now, something has to come for the 9th floor, because DW1, the evidence is also very vague. DW1, page 40.
Yes, madam, evidence is page. We don't want evidence is page
I think
35.
page 35. I think both of you can relook the evidence once again, because as you see in the 35 also, he talks about the incident occurred on so and so 7. I had gone to so and so. No, this is PW1, DW,
PW1.
DW1.
DW is
You had just referred.
yes, that's coming to it. Page 40.
Page 40.
Yes, DW. Uma Shankar Ram.
Yes, because you see, Mr. Kotoki, here also you are not, he's not deposing as when the 9th floor was
That part
completed.
has not come. Yeah, I understand. That
Now,
part-
in the absence of that, how do we assume that this 9th floor
That-
was
yeah, that-
prior, before the amendment
Or after them.
or after the
Yeah, I
amendment?
understand. That part is not there.
That is not there.
That is a difficulty. Man. They also have not brought any evidence to the effect that 9th floor was constructed. Because earlier inspection, it was up to 8, 6, 7 and 8. That was there in 92. In the meantime, from 92 to 2000, there may be construction. That part is not.
Mr. Bora, then how did the trial court and appellate court have convicted him when there was no evidence?
Not sure, like,
Because on record, it comes that the 7 and 8
In
was
92,
a 92.
7 and 8 in 92.
Now, when was this constructed?
92 to 2007 is long, more than 10 years. 11
Certainly
years.
it was the accused ought to have, but then you are the prosecutor. It was your duty to first prove that the construction, alleged construction is after 92. You may have, I may accommodate you.
No, so Lordship, accommodate me, the construction of 9th floor should have come after, on 17/8/2006 or after that.
Correct, correct. Only that.
That-
If you show it is after,
Lordship,
I
I
am
will
not
exam-
interfering.
Yes, I-
But if you don't have anything to show, then perhaps an error has caused, because the findings appears to be perverse. On what basis?
Lordship, I will examine the record.
You examine the record,
That-
because
that is the
there
only
should
issue.
be something. When should you have it?
Next week, man.
Next week? Okay. Relist.
Bill past week, man. Past week or week.
Did
Yes,
you, did you?
On 4th.
I'm not reflecting all this, but
Lordship,
Yes, yes.
Lordship, Lordship.
because that is the short
Yeah,
point,
and that is the four issue, man.
since you are before the
Class of the
revisional
matter.
court. Huh? Fourth? Okay,
Fourth.
4th April.
Lordship.
Yes.
Item 14,
Go further here.
So item 14, Lordship, there is two respondents, respondent number 1 and 2. One is the informant, Lordship, but I have not seen, Lordship, that the notice has been sent to respondent number 1, Lordship, because it is a CR case.
But petitioner is not there today.
But it is in hearing column, but notice was not sent to him. He is a complainant and it is a CR case.
None appears for the petitioner, relist on Friday in the order column with remark for dismissal. Mark the presence of Mr. Locker APP.
Item 15 and 16.
Yes.
My lord, I pray for some time in this case. Because only some, for my. there's
You want
some
some
doubts-
accommodation?
Accommodation, because I have some doubts in one issue.
All right.
But it's a 202 compliant, but whether the magistrate himself has gone for an inquiry. Again, he has taken the statement. Just.
Mr.
that-
M. Bora, Learned Senior Counsel, assisted by Mr. N.K. Kalita, Learned Counsel for the petitioner, seeks some accommodation in the matter to verify the
Order of the magistrate.
order of the magistrate in order to assist this court effectively. Prayer is allowed. Relist when?
After being
Didiba.
25th.
interim control.
Interim, if any, shall continue till the next date of listing.
Item 17.
Yes, anyone appearing for the appellant in item 17? On the last occasion, Mr. Kadir had appeared and he submitted that as the criminal appeal has been listed, all of a sudden he could not prepare properly. And today he is absent. We'll call it after some time. If he's still not there, we may appoint someone from the amicus. This cannot go on like this. It's a whole appeal.
Item 18 and 19.
18 and 19 also same lawyer. 17, 18, 19 it was of same Niki.
18 and 19 analogous.
Yes, but the lawyer seems to be the same.
Yes, Lordship.
Item 21.
Mr. Biswas was here.
Yeah, please, Your Lordship, kindly pass over for a time being.
All right.
Item 22.
22 also, Mr. Biswas.
Yes, he's on legs in court number 16.
Okay, time being.
Item 23.
Yes, Mr. Bora.
Well, look, it's a very small legal issue is involved regarding the taking up the complaint and the procedure to be followed. Well, in this case,
You are challenging the cognizance order.
yes, my lord, impugn order at page 26, my lord. My lord, in this case, cognizance was taken under section 228 of the IPC, my lord.
228.
228 of the IPC, my lord.
Yes.
Then my lord, this is he was an SI, this petitioner. He is the Kamaikha Mr. Now, Lordship, kindly come to the complaint at page 16 first.
He is what? He is
He is an SI.
SI.
Yes,
The accused is an SI.
yes, Sub Inspector Mala. So he was directed to execute an warrant,
Page?
page 16, my lord, the complaint.
Yes.
Respected sir, with due respect, I would like to inform you that the aforesaid person on appearance before this court on 26th day of December 2019 about 11 AM on execution of the process against him in connection with the GR case number 7434/11 started derogatory remarks towards the court. According to him, court commits mistake and they used to suffer the execution of process. This court was asking SI as to how this court supply the order particulars of the accused, namely Hanif alias per the previous record of the police in connection so and so, because it is the police who has investigated the case, and it is the police who collected the details address of the accused during the investigation. On such question, SI replied that it is not his duty to record every duty of the accused on execution of process. Moreover, SI on one step further start having the tempered manner and starting insulting the judicial process by saying that this court failed to understand his reports. The behavior and attitude of the SI is highly insulting towards the court as well as towards the judiciary. After repeated direction to remain silent, he was showing the insulting behavior in front of the staffs of this court, learned APP and some other learned advocates. Hence, finding no other means, this court is calling PI directed the accused to be taken away. The accused probably now in the PI office. In the said SI, with his words, conduct and behavior has clearly committed an offense against the administration of the justice. Sir, in the fact and circumstance of the above, I hereby request you to register a complaint as a complaint case to proceed with the case according to the law. The staff with this court, some Rigu Kun, so and so, so and so, so and so, advocate so and so, other advocate present before this court at the time of the incident. So this is the complaint by A. Hazarika, Judicial Magistrate First Class, Kamrup Metro. So accordingly, my lord, complaint was filed and now cognizance lordship order at page 26. Page 26. By the CGM, my lord. Date 26/12/19, case record registered on the basis of the complaint submitted by C. A. Hazarika JMFC against the accused Kamakhya Mishra SI police presently posted in so and so, so and so, so and so. Accused passed a derogatory remark towards the court by insulting the court in public view. Case is kept in my file for the trial and disposal. As the complaint is a public servant, according to the initial statement is spent to it. After going through this material available in the complaint, I find a prima facie case triable against the accused pendant under 228 IPC. Accordingly, a cognizance is taken accused under 228 IPC. Seen the and heard both sides of the bail petition on the accused person who is produced before me, PI office. Considering the fact the section 228 IPC is bailable, bail petition is allowed. Accordingly, accused is allowed to go on bail of 25 rupees with the surety of the like amount in default of the judicial custody. So this is the cognizance order. So now the procedure in this kind of cases has been very specifically laid down.
Let's come to 228 first.
228, my lord. Intentional insult or interruption to the public servant sitting on the stage of the judicial proceeding. And the simple imprisonment for a 6 months or fine of rupees 1,000. It's a non-cognizable bailable offense. Now, Lordship kindly also see this is the one peculiar case, my lord, the procedure, who can try these offenses, my lord. The provision is the court in which the offense is committed.
Where are you reading from?
The CRPC, my lord, Lordship also can see the CRPC also 220.
Yes, section
228, my lord.
228 I've
No,
seen.
yes, my lord, the chart, my lord. Sorry, my lord.
Chart.
Chart of the CRPC schedule, my lord.
Part of this?
Schedule, my lord.
Oh, okay.
Schedule of offenses.
Yes.
228, my lord. Schedule offenses. The
28,
first
yes.
schedule itself, my lord,
Yes.
by what code tribal? 6 column, my lord.
Yeah. The court in which the offense is committed subject to the provision of chapter 26.
Yes. So in this, whatever the allegation, this is happened in the
In the
judicial-
court of judicial.
judicial magistrate first class. But as per this particular. this is the
CJM has.
Yes, CJM.
Because the complaint was filed before the CJM's court.
CJM. But this is the only case, my lord. The procedure where the court, where the offense is alleged to be committed, he has to take up the case itself.
So in that, if that is this your sole ground?
No, that's true. My
No,
base,
because otherwise, Mr. Bora, if reading by the government set in the complaint, it appears that
yes, yes, no,
the
I'm not on that, but
conduct-
the procedural lapse is there.
if this is one of the procedure lapse, if
Yes,
this.
that
this
can
court
be cured.
yeah, yes, this
That
court
can be
can
cured.
direct that.
Yes, yes.
the matter
That can be cured.
Yes,
But the second part,
yes,
the whole cognizance order cannot stand
yes.
because at the complaint of, now logically see 195, my lord,
195.
195, CRPC.
Yes.
Offenses under this.
Yes.
Equate to 195. no? Now, may I read 195?
Yes.
No court shall take cognizance. A Roman 1, if any offense punishable under section 172 to 188, both inclusive in Indian Penal Code, any abatement or attempt to commit such offense. 3, any criminal conspiracy to commit such offense, except on a complaint in writing in a public servant concerned or of the same other public servant to whom the administrative subordinate. Number B, B1 money. Any offense punishable under any following sections of the Indian Penal Code, namely 193 to 196, both inclusive. Then 199, 200, 205 to 211, both inclusive. And
Where that B1,
B1,
which are the sections? 193,
193 to 196.
And 228.
Yes,
When
then
such
last
offence
is
is done.
228.
Yes.
When such offense is alleged to have been committed in or in relation to the proceeding in any court.
Except on the
Except-
complaint in writing of that.
Except on a complaint in writing of that court or by such officer of the court, as to court may authorize in writing on this behalf or some other court by which the
So
court is
here,
subordinate.
an officer has written the complaint, correct?
Yes, yes. Now, Lordship, kindly see the
Then
one.
Isn't this little contrary to, but then for 228, because in 228, it is the court in which
Yes.
the offense has alleged to have been committed is the competent court to take
Take
cognizance,
trial can take
correct?
place, yes.
Now, in that situation, a complaint may not be necessary because that court is taking cognizance. Even if a complaint is required, that
Complaint
complaint
is
will be
required, ma'am.
by the officer of that court
Officer of the that court, but this.
or himself.
Of himself, but or by his subordinate, they can file a complaint.
Now
That's it.
here, who has filed?
Here he himself is filed it. He himself is filed except on a complaint writing by that court. So in that court itself, my lord, we are not disputing that, my lord.
Okay,
He has fulfilled that particular.
okay.
Now 340, my lord, this is important.
So
CRPC,
basically, under 195,
the procedure has been laid down under
and
section
that is
340.
till here, it has been followed
Until here is followed.
until here. Okay.
Until here is followed. Only, my lord, next part is more important. That is the
340.
195, the procedure has been laid down under 340, my lord. How it
That
should,
is for section 195.
195.
What about 280?
No, 280 falls under 195, my lord. For every
Okay, because of B,
Yes,
because of B1.
yes.
All right, all right.
So provision as to offences affecting administrative justice, my lord. 340.
Yes,
Now, Lordship, 340 procedure in cases mentioned in 195. So it is under 195. So all the procedure which fall for offences under 195, this procedure has to be followed. 195.
in that case, I'm sorry, I'm cutting you short, Mr. Bora. This court can always send the matter back to the court.
To
and
follow the
to follow-
340.
To follow 340 procedure.
340.
And also, because this cognizance order is wrong. So I will set aside the cognizance because as per that schedule, 280 cognizance has to be taken by the court in which.
And the
alleged
340, there has to be compliance of 340.
So, and I will say let the
Yes, yes.
matter, I think that would be.
That is sufficient.
That
340.
is sufficient,
That is
isn't it?
sufficient.
Because otherwise.
The whole thing will not go, my lord.
Correct, correct.
Whole
That
thing
is
will
why,
not go,
that
my
is
lord.
why I cut you short, because
The
if that is your argument.
Yes, yes.
So,
The whole thing will, but they have to follow to be cognizant 340. Their procedure laid down
now
is
this
340.
matter will now send back to the court of CJM.
CGM, then he will decide accordingly, my lord,
Okay.
where to proceed with following the 340.
All right. Anything, Ms. Bora, are you there in this case?
Lordship can also rely on the one judgment 340 regarding how.
Here, there is no private respondent. No, only state.
No, no.
Para 7, my lord.
Heard Mr. A.M. Bora, then senior counsel assisted by Mr.
V.A.
V.A. Chaudhary, learned counsel for the petitioner. Stop. Also heard MS Asit Bora, learned APP for the state respondents. By way of, there are two petitions. Two
One
petitions.
One petition. Lord.
One petition.
Sorry. By way of this petition, you may take your seat, Mr. Bora. Ms. Bora, take
All
your
right.
seat. By way of this petition under section 482, read with section 401 of CRPC 1973, the petitioner is seeking quashing of the order dated 26/12/2019 and proceedings of complaint case number 5078/2019 pending in the court of learned Chief Judicial Magistrate Kamrup Metro at Kohani. Stop. The brief facts of the case is that the petition is the brief facts of the case is that Mr. Bora, can I resume in 5 minutes? I'll just take a short break.
Well, he'll be there. I'll take.
No
leave.
problem, you're excused. Mr. Chaudhary, just hear out the facts. Brief facts of the case is that on 26/12/2019, one complaint is by the judicial magistrate one Omarando Hajorika, Assam Judicial Service, within bracket AGS, lodged a complaint case before the court of the learned Chief Judicial Magistrate Kamrup Metro, alleging inter alia that on 26/12/2019, the petitioner, on appearing before this before the court of court of judicial magistrate first class, court of judicial magistrate first class, before his court, I so and so, on 26/12/2019 at about 11 a.m. on execution of process against him in connection with GR case number 7434 of 2011, stated derogatory remarks towards the court, and hence he committed mistake. No, derogatory remarks towards the court, and further stated that the court committed mistake for which he suffered for execution of the processes. It is further alleged that accordingly, the Chief Judicial Magistrate, by judgment by order dated 26/12/2019, took cognizance against the petitioner under section 228 IPC against the aforesaid complaint, as well as the order dated 26/12/2019 passed by the Chief Judicial Magistrate Court, the present criminal petition has been filed. Mr. M. Bora, Learned Senior Counsel, by referring to the schedule this is the schedule 1.
First schedule.
By referring to the first schedule,
Capital I offenses under the IPC. That is the subheading. That is the subheading, offenses under the IPC.
Relating to offenses under the IPC, submitted that in connection to section 228 of IPC, it is provided that the court in which the offense is committed, subject to the provisions of chapter 24, is the court which will try the said offense.
The heading is the 6th column. By what court triable?
I will come to that.
Lot.
I've already said this is a submission. Where is chapter 24, 26? Oh, this is 340.
26, 340.
So under subsection 2 of section 340, Mr. Chaudhary, in case that court doesn't make any complaint, then the court which is superior to that court can also
make.
correct. But isn't it? Just read para 2, subsection 2 of 340. Because in one it says, when upon an application, any court is of the opinion that that an inquiry should be made, so and so, which appears to have been committed in or in relation to proceeding in that court, or in the case maybe in respect of so and so. Such court, isn't it?
Lordship,
And then the power conferred on a court in respect of any offense made may in any case where that court has neither made a complaint, then
and there is a preliminary inquiry also, Lordship, that also has to be.
so those are procedure.
Procedure,
Yeah,
all are
okay.
procedure.
He further submits that the provisions, the procedures provided under section 340 to try the cases, to try offenses under section 228 IPC is provided under section 340, which has not been followed in the instant case. He accordingly submits that the order of the cognizance by the Chief Judicial Magistrate Court is accordingly erroneous in law. Reacting to the aforesaid arguments of the learned senior counsel, MS S.H. Bora, learned APP for the state respondent, fairly submits that since the court which took cognizance of the offense under section 228 admittedly is not the court in which the offense is alleged to have been committed, this the matter can be remitted back to the court of CJM for doing the for passing necessary orders as per law by following the procedure prescribed under section 340 of CRPC. Correct. That should be sufficient. That is her submission.
Yes.
Heard, sir, Koridipa. Apt to reproduce the complaint. Dated so and so, page 16, A to A. Okay. It appears that after going through the materials available in the complaint, the Chief Judicial Magistrate, the Chief Judicial Magistrate Court, the Court of Chief Judicial Magistrate, took cognizance under section 228 of IPC against the petitioner. It is apt to reproduce the relevant portion of the schedule of the first schedule appended to the CRPC, which is reproduced here under for ready reference. To me, yet first thought to me.
My petition, page 11 also I have reproduced.
You have given?
No. Page number 11.
Yeah, Padidiba. Reproduce the relevant portion of the code of CRPC 1973, A to A, page 11. Okay. Apparent reading of the first schedule that it is the court in which the offense is committed is is competent to try offenses under section 228. Stop. That it is further apparent that the cognizance has been taken by the court of CJM and not the court of judicial magistrate first class, where the offense is alleged to have been committed. That being so, this court, that being so, the order of the order of the CJM taking cognizance cannot stand in the cannot stand in the scrutiny of law, and as such, the order dated so and so is set aside and quashed to that extent. I therefore, in the interest of justice, allow this criminal petition setting aside by setting aside the impugned order of the magistrate court taking cognizance against so and so and remit the matter to the CJM so and so to decide the application under section 340 CRPC afresh in accordance with law, keeping in mind the first schedule appended because how do I think that direction has to be also here, because ultimately it has to be decided by the judicial magistrate court.
Yes.
So this direction should go to whom?
Lordship to the CGM, because it is given to the CGM.
To the court of CJM to do the needful in terms of the first schedule to the CRPC so and so, and after and the competent court thereafter decide the same afresh in accordance with the procedure laid down under section 340 CRPC.
Gotcha.
I think that should be sufficient. All the contentions accordingly are, all the other contentions are left open to the parties to be raised before the learned. No, it will be what I like. So and so stands allowed.
Deeply obliged. Deeply.
And big item number 2.
Yes. Still nobody has come.
Yes, Lordship. Additional affidavit was supposed to be.
None appears for the petitioner on call. It appears that on the last occasion, the petitioner, the learned counsel, that the petitioner were directed to file an additional affidavit as per the request made on that date. However, neither the additional affidavit is filed, nor there is any representation on behalf of the petitioner on call. Heard
El Shagar.
Huh?
El Shagar.
So and so and Bora APP. Relist on Friday in the order column with the remark for dismissal.
Time being item number 17.
That query, but despite none appears for the petitioner today, none appears despite the matter being called twice.
Sorry, my lord.
Item number
17, my lord.
17.
My lord, but this is April, my lord.
Yes, Mr. Kadir.
Yes, my sorry, my lord, I could not.
Yes.
My lord. My lord,
Because
this is an appeal, my lord, against conviction, my lord. And what happened, my lord, in the same incident, my lord, 2 appeals are there, my lord. One appeal filed by the present,
the other appeal is not listed.
not listed, my lord.
Which is
have-
the number?
I have parts in my lord, 250, my lord, 250.
Mr. MJ Kadir, learned counsel for the appellant submits that the connected criminal appeal I criminal appeal number
250
of 2018
18.
is not listed today.
Yes.
Relist the appeal along with so and so in the month in the third week of April uh, 2025 on a date to be fixed by the registry. Third week হবো না?
Third week holiday থাকে।
Fourth week.
Fourth week।
In the fourth week.
18
In the
and
month of May, in the month of May, a date to
May.
be fixed by the registry.
My lord, 18 and 19, my lord, these two matters are, my lord, appeal against acquittal, my lord. Under section 376, my lord, and my lord, the victim is a my lord, very poor lady, and he is a servant, my lord, serves some other person's houses, my lord. And my lord, regarding some instructions, my lord, I could not contact her, my lord. So in this case, my lord, these two petitions may
What
also,
instruction you need in an appeal,
my
criminal
lord,
appeal?
appeal against acquittal, my lord,
Yes, but what instruction do you need?
regarding some personal status of the girl, my lord, whether she is whereabouts, my lord, I could not. After Bihu vacation,
How is that material?
my lord, immediately after Bihu
How is
vacation,
that material?
yes, my lord. Immediately after Bihu vacation, my lord, some other persons, my lord, contacted me, my lord. Handed over
All right,
this.
Mr. M.J. Kadir, learned counsel, as prayed for by Mr. M.J. Kadir, learned counsel for the appellant, relist in the month of May on a date to be fixed by the registry.
Pending item number 21.
Yeah,
Lordship,
yes. Yes. Nirula,
is coming,
huh?
he, after some time can it be taken?
All right.
Item 24.
22 to কি হয়? None, huh? None appears for the petitioner on call. Heard, Mr. Lockhart and APB for the state respondent. Relist on Friday with the in the order column with the remark for dismissal.
Supplementary list, item number 31 and 32.
May it please your lordship, I apologize, my lord, for the last day, my lord. There was a gross misunderstanding of the resolution passed by the bar, my lord. I thought it is abstaining from work, therefore I was not
Ms.
present.
Chakraborty.
I apologize. The gross
Apology is accepted, but you see, even if any such resolution is passed by the bar, that doesn't mean that you will not come to the court
I
and
apologize, my
inform
lord,
the
yes.
court. You have a duty to the court. The court is not on a holiday,
My lord.
and there was no such resolution.
That was
It
my-
was a
my-
mere strike.
My misunderstanding.
It
my
was a
lord.
mere strike. This is not expected from a senior
I
member of the
apologize.
bar.
I apologize. What?
I think before we take up this matter, since Mr. Biswas has come, yes, because he was, let me take that matter, you wait for some time. I'll call Mr. Biswas's matter.
25, 21. Honor, this revision relates to an order and judgment passed by the learned magistrate as well as confirmed by the learned session court. I like with some modification. They are a married couple, my lord. They got married in 2010, but they are blessed with the daughter also. But in the midst, my lord, after 5 years, my lord, there's some misunderstanding between them, and for which the respondent lady left for her home. Then husband went to her house, persuaded her to bring her back. She declined to come. Then out of anger, this husband has pronounced the talak.
Huh?
Talak.
Husband has?
Talak.
Talak.
Yes. So thereafter, relation has been ceased, my lord.
Then she filed 498A against me, in which I got acquittal. Then she filed domestic violence against me, in which, my lord, there was an award of 4,000 rupees. And compensation, I do not know under what ground, what account or what head, 2 lakhs rupees.
In the case of domestic violence.
Domestic violence. So that was challenged by the before session court.
Appellate
Session
court.
court has under appeal, my lord. Session court has reduced the compensation amount 2 lakhs to 1 lakh and maintenance amount 4,000 to 3,500.
Maintenance.
3,000 to 500
Maintenance.
maintenance. So,
What is the error?
Error means like whenever compensation is granted, it must given under some head. There was no mention under what head. Whether it is health.
There must have been some reason given.
Cannot be. Law doesn't provide like that.
Which is that order?
Domestic violence, I'm reading the order of the learned magistrate, my lord, that is in page 11, my lord.
Page?
Page 11.
Yes.
In the case under 12 of the Protection of the Women from the Domestic Violence Act 2005, aggrieved Rahima Begum Laskar has stated that she was married to the respondent number 1 on 7th 2010, and after the marriage, he agreed went to stay into the house of the respondent, and her conjugal life was happy during the first year, and a daughter was also begotten during their period. However, during the pregnancy period, respondent 1 did not provide adequate treatment and care for the petitioner. At the instigation of the respondent number 2, the husband of the aggrieved started mental and physical torture on her, and he also demanded rupees 1 lakh from her. But the said demand could not be fulfilled by the aggrieved. However, the father of the aggrieved gave 50,000 for some time. The torture upon the aggrieved stopped. But the respondent again demanded balance amount of within the aggrieved could not pay this, then the cruelty upon the aggrieved by the respondent increased. On 24/11/11, during the night, aggrieved was forced out of her matrimonial home by respondent number 1. On getting the information, the father of the aggrieved took the assistance of the police, and during her stay in the home of her father, her husband did not provide any kind of relief. So the case started under section relief under section 18, 19, 20, 21, and 22 of the Act. On receipt of the petition, notice was served upon the respondent, and the respondent contested the case by submitting written objection. The respondent 1 stated that he or his family members never tortured the aggrieved. Respondent number 1 specifically stated that the aggrieved wanted him to live separately from his father in a rented house at Hailakandi, which he refused. So the aggrieved
All
left
right,
his-
let's come to.
May it please your lordship.
Yes, please.
My lord, this is against a judgment, my lord, passed by the learned court of family court. The lordship finds it at page. There, my lord, an order of maintenance is there, which is under challenge. And there, while disposing the issue regarding maintenance, the learned court has gone beyond the issue of granting maintenance and decided the issue regarding validity of marriage.
Validity of?
Marriage. In a proceeding under 125, which is a summary proceeding. in
Why
nature-
there are two revision petitions?
There subsequently, there was another application for enhancement of the maintenance that is under challenge in a separate revision petition.
That was also rejected.
And that was also rejected. So now I'm paying 8,000 per month.
You are the husband.
Husband means there I denied the marriage. The issue here is that the petitioner before your lordship is a Christian by religion, and the girl is Hindu. Now she alleged that there was a marriage in Kamakhya temple, and there were some witnesses were there. They said that they have seen the marriage. He was there. And the case of the petitioner is that while he was pursuing this case before the family court, advocate was not allowed. and the evidences were recorded by the presiding officer
You
himself.
are before the revisional court.
So I understand. So I'm not going into those issues. I'm on the issue that whether, my lord, the court could have gone to that issue and the validity of marriage is
According to
identified.
you, the marriage was presumed without
Pres-
there being any
That-
concrete
that's
evidence.
it.
Is that what you're
That-
saying?
Yes, and secondly, the learned court below has said that the marriage was proved. How? Because they have also examined the court with as court witness the Kamakhya temple of some office bearer of registry.
So there is some evidence.
Some evidence.
Now, sufficiency of the evidence also cannot be gone into by the revisional court.
But then that certificate which was in issue, that is to be proved that none of the witnesses in that certificate who is alleged to have been signed those
Certificate of the marriage.
marriage. This is also not a certificate. He says this is a registration book where they have put their signatures and there are some witnesses.
But even
None
if
of-
that registration book is not proved, the evidence to the effect that there was a marriage between the petitioner and the respondent at the Kamakhya temple, that cannot be ignored.
My lord, but then in the meantime, what has happened now, it is a matter of 2004 and it was 6. And in the meantime, the girl has also moved an application before the court of CJM, which is the appropriate court for deciding the validity of a marriage. There she had alleged bigamy on my part, because the petitioner is already married with 3 children. So that case has been disposed of by the learned court of CJM, my lord, holding that she could not prove the marriage. So that is
That is a different aspect.
So these are
We have, where is the order of the,
lordship. It starts, my lord, at page 12, my lord.
page?
Page 12.
Both the orders under challenge are by the by the family court.
Family,
Why 2 orders? What is 69? That is the order.
my lord.
I thought you said subsequently went for appeal. No.
No. There's order dated 69 is under challenge in the first revision petition. The second revision petition number 138 of 2020, the enhancement of the maintenance from 3,000 to 8,000 is under challenge.
3,000 to 8,000.
Yes.
That is order.
Ordered. 16/9/2011.
Same order. 69 2011 is the order in.
69. Oh,
I am holding criminal petition, revision petition 4.
29. In 138. 138. It should be 29 to 35.
Page 11 and 138 application. 138, 2020.
Page.
Page 11, annexure 214 onwards.
I think I am holding a
16,
wrong
11.
file.
No, not this one.
This
This would be page
sorry.
11,
Sorry,
page 11.
yes.
It
Page
is
11.
dated 29/9
No, then,
2018.
then because the brief that I am holding is criminal revision petition 04 of 2012.
No,
The
04.
second one,
This is the second one.
second one is this
Second
one. This is the first one.
It is
Four
the first one.
4 is the first one.
Yes.
But here the order impugned is 16/9
Yes,
2012.
same order, one, they have challenged the maintenance
Oh, achha, achha.
and then enhancement in 2020, 138.
No, enhancement is that order date is different.
Yes,
Different.
different order. That is on
29.
29/9/18. That one, that challenge is afterwards, that petition.
29?
29/9/2018.
All right.
Annexure 1 in
Very well.
138.
That is the second case.
Second one, enhancement one.
Okay, understood. Yes, Mr. Chakraborty.
So, my lord, here in the first case, lordship finds the
12.
yes,
Page 12.
Yes, page 12 it starts, but lordship finds the
Page 16.
page 16 onwards. The court has given the
Please read.
decision. Yes.
Read.
So far, point number 1 is concerned, let me come to a deal with the evidence of petitioner who is examined as PW1. According to the petitioner, her marriage with opposite party was solemnized on 29/2/2004 in Kamakhya temple. She also proved material exhibit number 1 and exhibit number 2 and the photographs of their marriage in Kamakhya temple. She has also proved material exhibit number 3 and exhibit 4 are the photographs which are taken after their marriage. Thereafter, she went with her husband to the matrimonial home in Shillong. They lived together for 3.5 months in their matrimonial home. Thereafter, her husband opposite party got transferred to Agartala. At that time, the opposite party was serving as junior engineer Agartala MES. The opposite party used to visit her in Shillong when he was working in Agartala. She was staying with her mother-in-law in Shillong. Thereafter, her husband opposite party resigned from his job in MES and joined MESEB uh, after staying in Shillong for 3 months. The opposite party got transferred to Laska. He used to visit her in every weekend, but he never took her to the place of work. When she asked him why he did not take her to his place of working, a quarrel took place between them on 9/4/2006. On 23/4/2006, her father was ill, but the opposite party did not come to see her father. Her father died on the same day. She tried to call her husband opposite party, but he kept his phone switched off. After 9 days, she went to call her husband for Shraddha ceremony of her father. After 15 days, she returned to husband's house, but her husband found missing. She made search her husband and he was found in the house of his brother-in-law. The opposite party husband did not want to keep her in his house. Her brother-in-law went to drop her in Shillong, but the opposite party told her brother-in-law to bring the petitioner back to Guwahati. She insisted to stay with her husband. Her brother-in-law, Jatin Medhi, and her aunt, Shrimati Basanti Tiwari, left her in her matrimonial home, but she stayed there only for 15 days since her husband used to torture her. He used to throw articles towards her and provide non-vegetarian food to harass her, though she is a vegetarian. The opposite party kept on telling her to go back to Guwahati. After 15 days, when he came for Shraddha ceremony of her father, she went to her matrimonial home after 27 days, but she found her husband absent from the house. Her mother-in-law turned her out from the house. While she was in Guwahati during Shraddha ceremony of her father, the opposite party sent messages through mobile not to return to his house. Having no alternative, she took shelter at her parental home in the month of November 2006. She again tried to reconcile with her husband and went to her matrimonial home with her relatives, but the opposite party husband again turned her from his house. This witness has proved Exhibit 5 to be the receipt of Kamakhya Temple Trust Board. Exhibit 6 is to be the invitation card in her side. Exhibit 7 is the invitation card of the opposite party. Exhibit 7(1) is to the signature of the opposite party. She also has proved Exhibit 8 is to be the CD recording of her marriage. In cross-examination, the petitioner has stated that her father died on 23/4/2006. She had denied the suggestion of the opposite party that she did not marry the opposite party on 29/2/2004. This witness has also denied the suggestion of the opposite party that she did not stay with the opposite party for 3.5 months because it is not possible to stay from 3 months from 29/2/2004 to 23/4/2006. PW2 Jatin Medhi in his deposition stated that petitioner Jaya Arora is his sister-in-law. Her marriage with the opposite party was solemnized on 29/2/2004 in Kamakhya temple. After the marriage, the petitioner stayed in Shillong in the original house of opposite party. In the year 2006, quarrel took place between the parties. They went to Shillong. They met Jaya Arora and they left Jaya with Refill Star, opposite party, in his house. After his father-in-law's death, Jaya came to her parental home. After Shraddha ceremony of her father, PW2 together with Jaya's aunt went to drop Jaya in Shillong, but the mother of the opposite party turned her out from their house. Jaya was compelled to take shelter at her parental home. Again, after some months, they went to the house of the opposite party, but the brother of the opposite party assaulted Jaya. So on that night itself, they brought Jaya to Guwahati. In cross-examination, this witness has stated that he does not know the reason for quarrel and he came to know about the quarrel because Jaya called him over phone. This witness has denied the suggestion of the opposite party that opposite party and family members did not torture her. Renu Borkotoki, PW3, in her deposition stated that Jaya is her neighbor. The marriage between Jaya and Rifilstar opposite party was solemnized 2.5 years back. She knew the opposite party before their marriage. After marriage, Jaya used to stay in Shillong with the opposite party at his house. Whenever the petitioner came to Guwahati, they used to talk with her. After the death of father of the petitioner, Jaya and Rifilstar opposite party came to parental home, but petitioner used to stay in parental home. When they asked about her staying in her parental home, she told them that opposite party did not allow her to go back to Shillong. At present, petitioner has been staying in parental home. This witness had denied the suggestion of opposite party that she did not see the marriage between the parties. This witness also denied the suggestion of opposite party that she was not present in the marriage party and both parties did not get married. PW4 Srimati Bashanti Tiwari in her deposition stated that Jaya Arora is her niece and Jaya's marriage with Rifilstar opposite party was solemnized on 29 to 2004 in Kamakhya temple. After the marriage of the petitioner, they stayed with Rifilstar in Shillong. Jaya's father died of heart attack when he came to know about the quarrel between petitioner and opposite party. After the death of father of the petitioner, she stayed at her parental home for some days. Opposite party came on the following day of Jaya's father's death. After Shraddha ceremony, she and Jatin Medhi went to Shillong to keep Jaya Shillong, but opposite party's mother drove her out Jaya. The opposite party also refused to keep petitioner in his house, but she left Jaya at her matrimonial home. After about 1 week, petitioner again called her over phone. Opposite party used to pick up quarrel with petitioner and used filthy languages to her. Tapan, one of the friend of the opposite party, and Jatin Medhi tried to reconcile, but the petitioner was compelled to take shelter at her parental home. The brother of the opposite party also assaulted petitioner in cross-examination. This witness has denied the suggestion of the opposite party. They did not visit Jaya in Shillong in the house of the opposite party 3 times. The witness has also denied the suggestion of the opposite party, never tortured Jaya, and opposite party never married Jaya. The Ramel Das, another witness for the petitioner in his deposition stated that Jaya is his neighbor. The marriage between Jaya and opposite party was solemnized in Kamakhya temple in the year 2004. After the marriage, Jaya went to Shillong and started conjugal life with opposite party. In 2006, Jaya's father died. After Shraddha ceremony, Jaya was taken to her matrimonial home, but opposite party used to pick up quarrel with her. Brother-in-law of Jaya went to the house of the opposite party along with Jaya, but the opposite party assaulted her in front of her brother-in-law, Jatin Medhi. At present, Jaya has been staying in her parental home with her mother. In cross-examination, this witness stated that he did not see the quarrel between the parties, but he heard about the opposite party assaulted the petitioner in front of her brother-in-law. PW1 in her evidence has stated that her marriage with opposite party was solemnized on 29 to 2004 at Kamakhya temple, and after the marriage, they lived together as husband and wife in Shillong. He has exhibited some photographs to prove solemnization of marriage, that is exhibit number 1, exhibit 2, exhibit 3, exhibit 4. The evidence of PW1 petitioner found corroborated from the evidence of PW 2, 3, 4, and 5. So far, solemnization of the marriage with the opposite party is concerned. The petitioner also examined marriage register Kamakhya temple, who was examined as court witness, Shri Khagan Sikdar. The marriage register in his deposition stated that he is the marriage registrar of Kamakhya temple since 20 years back. He came to the court after receipt of notice from the court to bring the relevant marriage register about the execution of the marriage between Jaya Arora and Rifilstar Paikin. Accordingly, he brought the relevant marriage register, that is Exhibit A, and has proved Exhibit A1 to be the relevant page of the registration number so and so. That's serial number 840 dated 29 to 2004. Both the parties were present before him at the time of registration of their marriage and put their signature in the registration. From this witness has proved Exhibit A2 to be the signature of the petitioner Jaya Arora and Exhibit A3 to be the signature of the opposite party signed before him. Relatives of both the parties were present at the time of marriage registration. They put their signature in the register. From the side of the petitioner, one Darshan Arora, father of the petitioner, NP Das and Lakshmi Prasad Tiwari, relatives were present. From the side of the opposite party, his mother, Rakhi Paikin, E. Paikin and Ram Kantiram Bhuya were present, and all those witnesses signed in the register. Thereafter, he issued the marriage registration, receipt serial number so and so registration, by the exhibit number 5. So according to the record, marriage between the parties were registered before the Kamakhya Temple Trust Board on 29 to 2004. In cross-examination, this witness has denied the opposite party neither went to Kamakhya Temple nor signed the exhibit A in any point of time. The witness further has denied the suggestion of the opposite party that no marriage was solemnized between the parties. The evidence of the witness is of great importance. This witness is in his evidence has clearly stated that at the time of registration of marriage, both the parties were present and they put their signature in the registration form. He has also proved the signature of Jaya Arora petitioner opposite party, which is taken in his present. To rebut the evidence of the petitioner, the opposite party examined 3 witnesses, DW1. The opposite party in his deposition stated that he saw Jaya in a marriage party of his friend. In the said marriage ceremony, his friend introduced the petitioner with him. His friend One Tapan went to Shillong for sightseeing. The petitioner also came when they came along with them to Shillong. Jaya started to visit his house frequently. She came to her family members for sightseeing in Shillong. She used to visit Cherrapunji and other places sometimes. He and his family members also invited to Jaya's place. Sometime he could not come, but his mother and sister visited Jaya's place. Now this case has been filed against him. In cross-examination, he stated that he has forgotten the name of his friend. Tapan Bhuya is his friend and used to visit his house.
What is Exhibit A?
My lord.
What is Exhibit A?
Exhibit A. Hmm?
Exhibit number A.
Yes.
Chakraborty.
There's a list of these exhibits.
Yes, I have gone through. I'm sorry, I read little fast.
Oh.
But everything is against you. Marriage, how can you say marriage is not valid? He has, the defense witnesses, including the petitioner, may have denied the suggestion that he had married at Kamakhya, but he admits the Exhibit A. They all admit that they are their signatures. He admits the invitation card. These are exhibited documents.
My lord, what
On the basis, and he also exhibits the photographs. And not only he,
photographs were not proved, and
he admits.
his version is that
He has admitted that exhibit number 1, exhibit number 2, exhibit number 3, and exhibit number 4 are his photographs.
according to him, these were just written by the presiding officer when he
But
didn't.
admission is there in cross. This witness has denied the suggestion only to that effect, but he has never denied that these are not my photographs.
He said
And in DW2, she also says that in cross-examination, she has stated that in Exhibit A, she has written her name and it is her own handwriting. But she could not say where she signed it. Her mother also signed in Exhibit A. She identified the photograph. Now these, the DW2 and the mother are the sister and mother of the petitioner. Sorry.
But my lord, now at this
And-
point of time,
And the finding of this court is at page 22.
Yes.
This court doesn't find any error.
and my lord, page
Page
24.
23 on perusal. Please read that.
On perusal of evidence of opposite party DW1, it is found that though he has denied the solemnization of marriage with the petitioner, but he has admitted the photographs to be photographs of the petitioner with him after the marriage. According to him, my lord, these were recorded. He didn't understand because it was all in vernacular and he could not.
That admission
So-
is there.
And
I have also gone through
gone
the
through the
marriage certificate.
exhibit number A. And marriage certificate was proved by the
Proved by the marriage
was
registrar.
as
He has brought it as a court witness and
witness.
he had shown.
The-
He says that he's the one who solemnized. What more evidence do you need for the validity of the marriage?
My lord, the question is here, he is a Christian and this
Could be. Now, I am not getting into all this. It appears that there has been a marriage. It appears there has been a marriage.
and
The
court-
opposite party has admitted his signature in Exhibit A. to be his signature, and DW1 and so 2 and 3 have also admitted the signature of brother and mother of OP so and so in Exhibit A. There is no whisper in the evidence of the opposite party DW1 that the marriage was solemnized under duress. During trial, the petitioner has submitted the VCD of their marriage, and the said VCD was shown to the opposite party. A question was put by the petitioner as regards to VCD, but in reply, he has admitted that those are the photographs with petitioner Joya Arora.
My lord, the finding in at page 24 that according to section 7 of the Hindu Marriage Act 1955, Hindu marriage may be solemnized with the customary rights of either of the party.
So
This
here
finding
it has
not-
been done under the in Kamaikha. What if
Well,
a
this-
marriage is, if the conducting priest is saying that he has solemnized, what customs do you think would have been performed at marriage?
My lord,
In that
yes.
situation, all the marriages that happens in Kamaikha according to you are invalid.
No, my lord.
Then
My lord,
The
this may
marriage
not be the-
register of Kamaikha has been proved.
My lord, this may not be correct position of law, my lord, as my lord, the apex court has said
Hmm.
in a judgment that that
Yes, through me.
lordship, I'll just
Because if you can show me there is an error, then of course, you may have a case. But until unless you point out the manifest error, this court is not going to.
The moment he is in Kamaikha temple for solemnizing marriage, he accepted that.
No, but perhaps Ms. Chakrabarti is trying to say that he being from Christianity religion.
paragraph 16 of this judgment, my lord.
Paragraph
16.
Please give the reference so that
This is
Ms. Hussain can
2009,
have a look.
1 SCC 714.
Page
714. 2009, 1 SCC.
paragraph.
Paragraph 16 of this judgment.
What does it say?
Although an attempt has been made to establish that the Hindu Marriage Act 1950 did not prohibit a valid Hindu marriage of a Hindu and another professing a different faith, we are unable to agree with such a submission in view of the definite scheme of Act of 1955. In order to appreciate the same, we may first refer.
Did
to
you
the
make this argument or not before the?
Then, well, section and then in its paragraph 17, the word usage of the word expression may in the opening line of this section, in our view, does not make the provision section 5 optional. On the other hand, it in positive terms indicates that a marriage can be solemnized between two Hindus if condition indicated were fulfilled. In other words, in the event the condition remain unfulfilled, a marriage between Hindus could not have been a marriage between two Hindus could not been solemnized. The expression may used in the opening words is not directory, as has been sought to be argued, but mandatory non-fulfillment of those who permit a marriage under this act, Hindu section we read with section 5 Hindu and understood in section 5 sometimes according to certain in
This is between two Hindus.
and then one no,
Para 18. In the facts pleaded by the respondent in her application.
paragraph 18.
And the admission of the evidence that he was and still is a Christian belonging to so and so. The marriage ceremony in accordance with Hindu custom was a nullity and his registration and
Paragraph
possession
18.
could not. In our view, but this is on the facts. Now, what is the facts?
I don't think this is one, it is against 125 application.
No, this is not in one.
It cannot be, I cannot attract this one because 125 lordship, but there's a Dwarika Prasad Satpathy lordship, there's a leading judgment which says that for maintenance lordship, the validity of the marriage for the purpose of summary proceedings under section 125 CRPC is to be determined on the basis of the evidence brought on record by the parties. The standard of proof of marriage in such proceedings is not as strict as is required in a trial of offense under section 494 IPC. If the claimant in proceeding under section 125 of the court succeeds in showing that she and the respondent have lived together as husband and wife, the court can presume that they are legally wedded spouses.
Here you have already shown they
Yes,
married.
lordship.
There are evidence that they were staying together.
Now, the moment he goes to Kamaikha temple to solemnize marriage, the petitioner did not know that she was a Christian. We have stated that. He projected himself to be a Hindu.
Hindu marriage account for the
Section 7 of Hindu Marriage Act.
section 5 and 7.
The judgment what my colleague is referring is because of the marriage.
I've understood. I've
Yes.
understood.
Section 5, my lord, solemnized between two Hindus.
Which talks about intercaste.
Section 7, ceremonies for Hindu marriage.
Section 7.
Section 7, it's been referred by the court below, that Section 7 of the Hindu Marriage Act, since it says that a Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either of the parties.
either
Therefore,
party.
but my lord, if it is read in consonance with Section 5 of the Act, a
See-
marriage may be solemnized between two Hindus if the following conditions are fulfilled.
The presumption when he goes for registering marriage in the Kamakya temple,
But these conditions, which condition is applicable in your case?
My lord, here what I'm trying to project before your lordship, since he is not a Hindu.
Where is it a condition that Christian marriage and sorry, Mr. Chakravarti, maybe I'm not being able to understand properly your submission. See, now there are two things, right? Section 7 says that a Hindu marriage may be solemnized in accordance with the customary rites and ceremonies of either party. That means, suppose if one of the party belongs to another caste or under another law, then even that can be valid under the Hindu Marriage Act, provided the customs of one of the party is done, right? Now here, in your case, it has come that as per Hindu, that the marriage has been solemnized at Kamakya temple. Now, the moment that part of evidence is there, it will be presumed that the marriage is valid as per the Hindu law is concerned. Unless and of course you show or you prove that those conditions which are required under Section 5 is not present.
Because
that one of the spouse had one of the party has a spouse living at that time. That is not your case. That is incapable of giving a valid consent, unsound mind, suffering from mental disorder, attack of insanity. Where on this? Why are you bringing me to this?
But this is between, since Section 5, the opening letter says it is between two Hindus, since here is a party who is
Correct.
Christian and.
So maybe in that situation, we may say 5 is not even applicable. Now 7 and 5 have to be read together. If that is so, then when you are talking about a marriage under Hindu, to be law to be valid, then those conditions, if were there, perhaps we could have said that this marriage is not under the Hindu law. That is not your argument. Why are you relying on these sections?
and lordship, they had challenged the marriage also.
I'll come to you.
Sorry.
I'll come to you. You understand what I'm asking?
I understood.
Where is that you are saying?
So
Because-
I'm relying on this judgment also. of
Yes,
the
this
court that,
judgment, the judgments are contextual, correct?
I understand. Well, this is not in context with the 125 proceeding, of course.
Yes. — 125 is under section
CRPC.
CRPC. And you see, the Hindu Marriage Act otherwise doesn't apply to a Christian.
That's it.
To any other person domiciled in the territories to which this extends, who is not a Muslim, this act applies, who is not a Muslim, Christian, Parsi, or Jew by religion, unless it is proved that any such person would not have been governed by the Hindu law or by so and so, that law, so and so. So I think the act is not applicable otherwise to a Christian person. Now let's go to 125. which is that decision, Ms. Hussain, you are relying on 125?
Yes,
Please pass it on.
Dwarika Prasad.
Please pass it on.
Yes,
Do you have a copy? You have an extra copy?
Yes, Lordship.
I don't know dispute about this, that this is a summary proceeding.
And Lordship, they have challenged the marriage, the annulment of marriage, they have they challenged before the lower court. It has been set aside and they're before this honorable court in appeal, no? Until
Oh.
that appeal is not finished, I'm
Ajay.
still bound to get the maintenance, otherwise also.
That we are.
Where is that order?
Appeal is pending before.
Appeal is pending before.
No,
the
but
court.
where is the order which
So
says?
now it has subsequently it happened. So I'm not in that cases, that some other advocates are there. The moment the appeal is there, till the appeal is disposed of, I'm right, I have right to.
No, that we are paying, maintenance are
Yes,
paying.
yes.
it. But the competent court has already said that there is no marriage. They could not prove the marriage, but there's the judicial magistrate.
The evidence. Maybe judgment in all cases of maintenance, Lordship, which means.
I'll look into it. The truth is, then you all are familiar to the family law,
Yes.
but I hadn't had much exposure to
yes.
that
I
side
know
of
it's,
the law. That is why I'm just
But
trying
Lordship
to.
is trying
try my
very hard,
best.
we can see,
Best to assist.
we have seen it.
The explanation of 125, it doesn't say that wife means a valid
No, it can be anybody,
because
husband also, parents also, children also.
And subsequently, my lord, if I may say, that the person, if he is living together.
Living
they are
together.
also
Yes,
entitled.
yes.
So it has been relaxed to that extent.
Lordship, in 60, in this
Yes.
judgment, page 676, Lordship has got it.
Page?
Page 676 in the judgment itself,
Yes.
which I have given. Lordship will come to the last paragraph. Lordship has got an order. My one is 676. Lordship has got it.
676 is a head note,
Oh, this is another one that.
para 9 and 10.
Lordship.
I think it's
After health, Lordship, health, from health, I'll read from health. In health,
yes,
valid,
yeah.
Lordship have got it.
No, in para 9, how does it start, the paragraph?
Lordship, it starts here in the opening section, opening of the judgment, Lordship. The second, after all the cause title and everything, held the validity of the marriage for the purpose of summary proceedings, Lordship, got it? Actually, I have a different.
No,
printout.
that you are reading is the
I'm
head
reading
note,
it,
Ms.
it's a
Hussain.
printout, Lordship.
Why are you reading the head note? Come to the paragraph.
Yes, Lordship.
Paragraph
Yes,
is
yes, yes,
para
yes,
6.
yes, para 6, yes.
Yes. Read para 6. You have it?
Yes, Lordship. Learned counsel for the appellant at the time of hearing had not disputed the paternity of the child. Hence, the question is whether the marriage between the appellant and respondent one was valid or invalid. In our view, validity of marriage for the purpose of summary proceedings under section 125 CRPC is to be determined on the basis of the evidence brought on the record by the parties. The standard of proof of marriage in such proceedings is not as strict as is required in a trial of offense under section 494 IPC. If the claimant in proceedings under section 125 of the code succeeds in showing that she and the respondent have lived together as husband and wife, the court can presume that they are legally wedded spouses.
This is absolutely, it has been.
This I'm not disputing.
No, if you are not disputing this, then there is no error. There is no error. Because undisputedly marriage procedure was followed in the temple, that too in the presence of the so-and-so. It could be, one could be of Christian, but it appears that they both were living as husband and
It's
wife.
para 7, Lordship. There's
Isn't it? A marriage ceremony which she is admitted. So she was given the impression that she is married to this person.
Lordship,
Then how can he not be made liable to pay maintenance?
And this 8,000 was fixed into the. in the 2000
Subsequently, my lord, the
It's up-
competent court has found that there is no marriage because that
We have
where
challenged
this
that.
proof were different, of course.
No, we are challenging, we are.
Proof, sorry, Ms.
Yeah,
Chakraborty.
Paragraph 7 also, Lordship will point, mark it.
Paragraph 7,
Lordship,
yes.
what? It says, it talks about section 5 of the Hindu Marriage Act,
No, this is, I think, relied upon.
relied upon. No, no, it was not accepted. This contention was not accepted by the Supreme Court.
Okay.
In that case, the court confirmed the judgment of the High Court and arrived at the conclusion that the
It's in the present.
middle portion. The legislature decided to bestow the benefit of section 125 CRPC even on an illegitimate child by express words, but none are found to apply to a de facto wife where the marriage is void ab initio. That is a different aspect, Lordship, it will not come.
7 is not
Not
required.
required, not required.
I think 9. It is to be remembered that the order passed in application so and so does not finally determine the rights and obligation of the parties. And the said section is enacted with a view to provide a summary remedy for providing
Yes, yes,
maintenance to a wife, children, and parents. For the purpose of getting his right determined, the appellant has also filed a civil suit, which is pending. Observed, in such a situation, this court in so and so observed that maintenance under so and so cannot be denied where there was some evidence on which conclusion for grant
Yes,
of
Lordship.
maintenance could be reached. It was held that order passed under so and so is summary order, which does not finally determine the rights so and so.
Yes, Lordship.
That is what, and after not disputing the so and so,
It's not required.
that's not required. I think 6 and 9 should.
9,
be
yes,
held.
Lordship, Lordship.
Yes, Pranav.
Similarly, I have many different High Court orders. Also.
No, you don't have to multiply.
Little case.
Heard Ms. MSP Chakraborty, Learned Counsel for the petitioner. Also heard MSS
Parveen.
uh,
Parveen. SP Hussain.
SP Hussain, isn't it? SP Hussain, Learned Counsel appearing for the respondent. By way of the instant to revision petition, criminal revision petition 13, criminal revision petition S. Parveen Hoide, ticketer num.
Lordship, if I may interfere for a moment, my lord. Lordship, may kindly take note of this CR case, my lord, where the learned CJM has said that the marriage could not be proved. It is a subsequent development. Just Lordship, may incorporate in my argument.
But this is a civil matter.
Yes,
Lordship, it's
yes,
a it's a
just
civil
my
matter.
arguments. The court has taken note.
No, this is what? This is, what order is this?
This is, my lord, the wife had filed it before the
This
court of
is
learned
the
CJM.
judgment where your marriage is held to be not valid.
Not valid.
Okay.
She could not prove the marriage.
All right,
Lordship, if I just, Lordship will.
I'll deal with it, Ms. Ahmed. What do you want to say? Tell me.
So this will not come here because it's a 125 proceeding
my
altogether
submission.
different, even submission.
Yes, and not only that, as you have said, you have filed an appeal against it.
Yes, yes, that should
An
not be.
appeal is
there.
also pending.
Yes.
And be that as it may, as far as this case is concerned, they have to they have to point out an error.
Error.
Now, though, at that time, whatever evidence is there, on the basis of that evidence, both the
They-
courts have
all
held.
the DWs, they have admitted they're the signatures.
It's all right. You are SP Hussain or S Parveen?
Lordship, now because I now presently I write S Parveen also.
So I'll record your name as
S Parveen, Lordship.
S Parveen. Huh? PVD लिखिला. Petition I, Criminal Revision Petition 4 of 2012, wherein the judgment and ordered the by way of these two revision petitions, the petitioner is challenging by two revision petitioner IE Koye Diba. For revision petition, criminal revision petition 4 of 2012 and criminal revision petition 138 of 2020, comma, the petitioner is challenging the judgment and order dated 16/9/2011 passed by the Family Court Kamrup at Guwahati in FC Criminal number 244 of 2009, registered under section 125 CRPC, allowing the maintenance to the respondent. And which is the other case to Diok? And the judgment and order dated 29/9/2018, passed by the Learned Family Court 2, Guwahati in Miss Case number 191 of 2018, whereby altered the maintenance allowance by enhancing the same to rupees 40,000 per in words and number only per month.
8,000. Enhancing to 8,000.
In your
3 to 8,000.
in your sorry, where is it?
It is number page 11 of the page 13.
Okay,
madam.
okay.
So considering all the
no, no.
hardship maintenance allowance,
Whereby maintenance allowance of the petitioner is enhanced from 3,000 per month to rupees 8,000 per month. Okay. It appears that both the criminal revision petition are against the same. Accordingly, both the criminal revision petitions are taken up together for disposal. Sorry, by this common judgment. The facts of the case is that the respondent filed an application under section 125 CRPC before the jurisdictional family court, alleging inter alia that she was married to the petitioner on 29/2/2004 as per Hindu rites at Kamakhya temple, and thereafter she was physically and mentally tortured by the family members of the petitioner as well as by the petitioner. And that after and then later the petitioner refused to take her with him to his house and also demanded a sum of rupees 10,000 from her father. And that the family members of, and that when she had later on gone to the house of the petitioner, she was driven out by the family members of the husband. Accordingly, she prayed for an amount of rupees 4,000 per month as maintenance from the petitioner. Pursuant to the said petition, the the evidences, the petitioner filed objection, and thereafter both parties adduced evidence. Stop. The family court, after concluding the hearing, was pleased to hold that the petitioner that the petitioner and the respondent is legally are legally married, and that the petitioner had neglected to maintain her, and accordingly ordered payment of rupees 3,000 per month as maintenance to the respondent. Against the aforesaid, thereafter the petitioner, thereafter the situated thus. Okay, sorry. Thereafter, the petitioner, respondent, you filed the enhancement, na? You
Yes,
filed
Lordship, yes.
Thereafter, the respondent filed an application for enhancement of the maintenance, which the family court, after hearing the parties, was pleased to enhance the maintenance from 3,000 rupees per month to rupees 8,000. Against the aforesaid two orders, the present criminal revision petitions have been filed. Ms. M.S.P. Chakraborty, learned counsel for the petitioner, submits that the petitioner being Christian, being a Christian, the marriage between the petitioner and the respondent, who is a Hindu, is not valid, and therefore the order of the magistrate court directing maintenance is totally erroneous in law. She further submits that subsequently this CR case was filed by whom?
Filed by the wife.
She further submits that the respondent has also filed CR, it's a complaint case.
Yes.
Has filed a complaint case before the Court of Additional Chief Judicial Magistrate, being CR case number 126713, wherein the Additional Chief Judicial Magistrate Court, by judgment and order dated 29/1/2021, this case is for 496, the complaint.
That is what I'm saying. It will not come in here, Lordship.
We filed a complaint alleging 496 is what?
Bigamy.
Alleging bigamy
could not prove it.
against the petitioner.
She could not prove
wherein
marriage.
that wherein
Bigamy by
the
second marriage, no?
wherein the additional chief judicial magistrate by judgment and order Diasana held that the allegation of bigamy being not proved, the dismissed the petition, dismissed the complaint.
Actually, my lord, she could not prove her marriage, therefore dismissed her petition. Paragraph 23. I find the complainant has failed to prove the ceremonies of marriage
She
between
further, paragraph 20,
23 of this
she
judgment.
further places reliance upon paragraph 23 of the said judgment, which reads as under A to A, paragraph 23 to DT. Per contra, MS S. Parveen, learned counsel for the respondent, submits that the factum of marriage between the respondent and the petitioner being established on the basis of evidences adduced before the magistrate court, before the family court, before the family court, and the factum of and upon perusal and upon considering the evidences, the family court having come to the conclusion that the petitioner has not maintained the respondent, awarded maintenance, and the same being appreciated and reappreciated, and therefore there is no patent or palpable manifest error whatsoever in the judgment and order of the family court. She further submits that the decision of the additional CJM Kamrup in the complaint case relied by the learned counsel appearing for the petitioner is of no relevance, inasmuch as that is a criminal case where the standard of proof is not the same as required under section 125, as required under the section 125 proceedings, right? CRPC proceedings. She further relies upon the decision of the apex court in Dwarika Prasad Satpati versus Vidyut Prabha Dikshit, reported in 1999, volume 7 SSC at page 675, to buttress the aforesaid submission. Heard, perused, considered judgments. It appears that for the alleged non-maintenance of the respondent by the petitioner, section 125 CRPC application was filed before the family court. It appears that evidences have been led by both parties before the said proceeding. It further appears that where do I get the list of witnesses and exhibits? Anywhere it is mentioned. In your paragraphs. Yes. Equalize both sides. If have been adduced by both the sides in these proceedings. Stop.
21 things on the.
Yes, I got. It appears that the respondent has adduced 5 witnesses, whereas the petitioner examined 3 witnesses, including himself. Correct?
Yes, sir.
It appears that petitioner, a respondent has also exhibited the the respondent has also exhibited the marriage certificate, comma, photographs of the marriage ceremony, comma, invitation card of the marriage, comma, that's all, huh? And the invitation card of the marriage.
CD also.
And VCD. And VCD in support of the marriage, in support of the alleged marriage. Stop. It appears that the marriage registrar, it appears from the evidence of the PW1 stroke respondent that the marriage between her and the petitioner was solemnized on 29/2/2024 at the Kamakhya temple. 2004 at the Kamakhya temple. And after the marriage, they lived together as husband and wife at Shillong. It further appears that in support of the aforesaid marriage, the respondent examined the marriage registrar of the Kamakhya temple as court witness CW1, who deposed that he is the marriage registrar of the Kamakhya temple since 20 years, and that he has brought the relevant marriage registrar, which is registrar to prove the marriage between the respondent and the petitioner. It appears that he has proved the contents of the marriage certificate, which is Exhibit A, and have deposed that the parties were that the respondent and the petitioner were present before him at the time of registration of their marriage, and they have and that the signature in the registration form are that of them. It appears that from the side of it appears that it appears from the aforesaid documents that the marriage was solemnized on was registered on 29/2/2024. The aforesaid evidence of the registrar is is not, it could not be shaken anyway by the by the petitioner. That apart, it appears that the petitioner has admitted during cross-examination the contents of the marriage register, the photographs, the invitation card of their marriage, and has also admitted his signature in the marriage registrar form. It further appears that the other defense witnesses has also admitted the aforesaid documents. Aforesaid exhibits, stop. It appears that the trial court, based on the aforesaid evidence, held as hereunder. Page 23. Page 23, paragraph, page 23, A to A, huh? A to A, page 23 to 25. Apt at this stage to refer to section 125 of the CRPC 1973, quote unquote, section 125. Reading of the aforesaid provision, it appears that while passing order under section 125, the family court is not determining the rights and obligation of the parties, and the said section is enacted with a view to provide a summary remedy for providing maintenance to a wife, children, and parents. In other words, the validity of the marriage for the purpose of summary proceedings under section 125 CRPC is to be determined on the basis of the evidence brought on record by the parties. Therefore, the standard of proof of marriage in such proceedings is not as strict as is required in a trial of offense under section 494 IPC. Stop. Thus, what is required to be shown, what is required to be established in proceedings under section 125 of CRPC in order to get maintenance is that the parties were living, but have lived together as husband and wife. Stop. If the aforesaid requirement is proved, the court is entitled to presume that they are legally wedded spouses. And in such a situation, the party who denies the marital status can rebut the presumption. Stop. Paragraph 6 and 9 of the decision of the apex court in the case of Dwarika Prasad Supra is reproduced hereunder for ready reference. It appears that in the present case, the respondent has been able to prove that a marriage was solemnized between her and the petitioner at the Kamaikha temple as per Hindu rites, and thereafter they had lived together as husband and wife. This is sufficient for the purpose of granting maintenance under section 125 CRPC. The decision, the subsequent decision of the additional Chief Judicial Magistrate Kamrup which was brought to the notice of this court, whereby the marriage of the petitioner with the respondent is held to be not valid for constituting an offense under section 496 IPC is of no relevance in the said proceedings, as the standard of proof required for the two proceedings are different. Further, it is submitted at the bar that an appeal has been filed by the petitioner and by the respondent against the aforesaid judgment dated 29/1/2021, which is pending before this court. Correct?
Criminal appeal 190 of 21.
Which is registered as criminal appeal
Number 190 of
190
90
of 2021,
21.
which is still pending. Be there as it may, it is apparent that the family court has committed no has committed no manifest or palpable error on the face of the record, and hence hence this court is of the unhesitant view that the order of the family court granting maintenance warrants no interference from this court. Further, there is no error whatsoever pointed out in the order of the family court enhancing the maintenance from 3,000 to 8,000, and hence the same is also not interfered with. The same is also not interfered. Resultantly, both the revision petitions stands dismissed. I'll edit it later. You want to give some?
There are 10 beautifully summed up by Justice Krishna Iyer, Lordship.
Where that
one
case?
case is 125, what is it?
6, 9 out of 20.
And the para 10
Okay.
last,
6, 9 and 20.
10, Lordship.
6, 9 and 20. I have already quoted 6 and 9,
No, yes, but
and I'll quote
when
10
they
also.
summarize that, the ending is very beautiful by Justice Krishna Iyer. What does 125 CRPC actually means?
Didiba. 10 to Didiba.
Cannot hit out as a 9-2.
That's all right. He'll quote it.
Yes,
Thank you.
obliged, Lordship, obliged.
There is a missed case.
Yes, interim
case
was,
what?
it was not taken up. There was no interim order.
So the missed
is
case
disposed of.
accordingly stands disposed of. Here we go. Didiba Nidhi. Hindu Act. Rihanna.